23rd 6. One of your lordship may kindly add us with this one.
I cannot understand.
Your lordship may kindly add, and if this one, if this may be on Friday.
Application, all right. Yes. Yes.
Lordship. May I permitted to mention, Lordship, compassionate appointment matter is pending for a long time. If you kindly, Lordship, exchange affidavits have been made. If your Lordship kindly list it in the under heading hearing.
Please wait for some time. Please wait. Yes.
Well, may I permit to mention one matter, my lord, for to be mentioned, my lord, because your lordship is directed for filing affidavit, not yet they have filed affidavit, my lord.
All right.
May I permit to mention, my lord, item number 134, today's list, my lord. My lord, the matter is appearing as returnable motion since 1st May. In the meantime, my lord, they have already completed the selection process. Your lordship granted admission order by putting a new name of the post. Kindly some upgradation, my lord, otherwise they have already completed the selection process.
All right. It will appear as for orders tomorrow.
Yes, ma'am.
My lord, may I be permitted to mention, my lord, this matter was heard on 13/6/2023.
Wait. Yes.
Item number 8.
You will have to wait. It will be called on. Yes.
Your Lordship, may I be permitted to mention as WPA number 16950, which were ordered by this honorable.
Speak on the microphone.
Your Lordship, and in WPA number 16950,
Yes.
that the order was passed by this honorable court on 28/6. The writ petition, year of the writ petition is wrongly appeared in the
All right.
order.
It will appear as to be mentioned.
Much obliged.
May I mention, Lordship, item number 178 of today's list, Lordship. Lordship remembers, Lordship, it's a matter, Lordship, it's a proceeding before the controlling authority. It was stayed, Lordship, due to the pendency of this writ petition, Lordship. Your Lordship, last occasion was taken up the matter, directed the matter will appear under the heading U motion, Lordship, but it will appear under the heading returnable motion, Lordship, because we are appearing on behalf of the workmen's, Lordship, they are not getting gratuity, Lordship, due to the pendency of the writ petition, Lordship. Last auction, Mr. HON'BLE was appeared, Lordship. It's a matter, Lordship.
I it to appear as new motion.
So, Lordship, but it
I do
is
not think
appearing
so.
under the heading motion, Lordship.
How can it be new motion? It
Just
has
gone
gone
down.
down.
Considering the fact that, my lord, because of the pendency of this, my lord, the proceedings before the gratuity authority has been, my lord,
It
automatic.
took time.
Yes.
There was no other order in that.
No, my lord, there was an order. Your lordship, it was adjourned because of the, my lord, accommodation
Yes,
sought
yes,
for by
yes,
the Union of India. My lord.
Yes.
My lord, it is, my lord, it was, my lord, it failed from your lordship that it would be coming under new motion, but in the order it has been recorded as motion.
All right, you give it to him. It will appear as new motion.
My lord, may I be permitted to mention, my lord, the matter was heard on 13/6/2023, but we cannot collect the certified copy because the file is yet lying in this court.
The file is not lying in this court.
Lying in this court.
Lying in this court. Please give him the slip. Let him look into the matter.
My lord, may I be permitted to mention a matter? This is writ petition WPA number 10160/2023. My lord, by order dated 18th May, I'm appearing for the respondents, Airport Authorities of India. You had granted us 6 weeks time to file our affidavit in opposition. But my lord, the facts of this matter date back to 1990, and it is pertaining to pension of some employees who were transferred from civil aviation, from Central Public Works Department to Airport Authority of India. They are asking for similar treatment as which was given to civil aviation department employees. But ma'am, your lordship, since this matter date back to 1990, there's a lot of coordination required from the headquarters in New Delhi.
So you want extension of time?
Yes,
Right.
my lord.
It will appear as to be mentioned. Please give.
Grateful, ma'am.
Have you given notice to the other side before mentioning?
Yes,
It will appear as
we're
to be
mentioning
mentioned.
on no. Grateful, your lordship.
Restoration application.
Please give the slip.
My lord, I am for the petitioner in this matter. My lord, on the yesterday the matter appeared, Mr. Bhaskar Bushu appeared, your lordship directed me to intimate him. I have intimated him.
Yes, he is appearing. Mr. Shah is appearing.
My lord.
I am for the state respondents.
Yes, yes.
My lord, the petitioners were initially appointed as 2020, my lord, as COVID warriors to work in hospitals and other temporarily by virtue of notifications of the central government, my lord, petitioners were appointed temporarily to serve the in different hospitals and clinics, my lord. In the meantime, my lord, the central government issued a notification that since they are working in these hard times, if any, to all the states and union territories, a notification was issued that if any recruitment is made to any health department, these COVID warriors who have worked for more than 100 days should be given preference in any recruitment. This was the notification of the central government. Our grievance is, my lord, after that, after we worked, everybody worked more than 100 days. My lord, the state government issued, the health department of health issued a notification for recruitment of contractual employees under the National Health Mission, my lord. Our contention is, in terms of that notification of the central government, no preference has been given to any of the COVID warriors. My lord, we want any preference of any kind. It may be relaxation of marks
Show
or
me the central government's notification.
My lord.
And show me their recruitment notification.
My lord, central government notification starts from page 23, my lord. And the relevant portion is at page 24, my lord, 17.17. My lord, may I read?
Yes.
The central government recommends to state/union territories governments to consider giving preference in regular government appointments of health professionals through the respective public service commission /other recruitment bodies for those health professionals under this special scheme who completed a minimum of 100 days of COVID related duty. This is the
now show me their notification.
My lord.
Now show me their advertisement.
Yes, ma'am.
Recruitment notification.
My lord, kindly come to page 140. My lord, this is the advertisement. Nothing has been stated regarding giving any sort of preference to any of the COVID warriors.
You have paid the court fees?
Yes, my lord.
Please hand over the slip to my officer.
My lord,
Yes, Mr. Shah.
may I submit, my
Yes.
lord? My lord, this recruitment notification, it is purely on contractual basis. It is stated that creation and filling up a post of 11,521 HR positions on contractual part-time and outsources basis.
Yes.
It is clearly stated.
Yes.
If you lordship kindly once again come to the page 24, my lord. Here as clause 17, my lord, as he has, my learned friend has already submitted before your lordship. If your lordship kindly peruse this clause 17, the central government recommends to state/UT governments to consider giving preference in regular government employees, appointments of health professionals through respective public service commission or other recruitment bodies for those health professionals under the special scheme who completed a minimum period of, my lord, 100 days of COVID related duties. Therefore, my lord, this recruitment process, this is not, my lord, for regular, my lord, appointment. It is totally, my lord, a contractual appointment. Therefore, this contention of my learned friend is not at all correct. This is my first submission before your lordship. This relaxation only provided for the regular government appointments of the health professionals and or allied healthcare service professionals. This is the first one, my lord.
Yes.
And the second, my lord, secondly, there, my lord, the petitioners before your lordship are not at all, my lord, they are my lord, health professionals, as per, my lord, the relevant rules of the, my lord,
Why do you
central
say so?
government and the WHO,
Why
World
do you
Health
say so?
Organization. I have the documents to show before your lordship. Here, my lord, from here it will be clear that they are not the, my lord, healthcare professionals.
All right, you file a report.
Lordship, that will be better.
You file a report. You put
Lordship,
those
lordship,
documents on record.
Lordship. But prima facie, my lord, they don't have any case regarding this, my lord. Regular appointment.
My lord,
and the,
every appointment, government appointment is a regular appointment, be it contractual. It is not that the regular appointment means
Regular
permanent appointment. There cannot be an irregular appointment.
The grievance of the petitioners is that despite working more than 100 days in COVID-related duties, the petitioners were not considered for engagement V-Day. They're not considered for engagement by way of giving preference title exit. V-Day recruitment notification dated April 28, 2022, issued by the West Bengal State Health and Family Welfare Samiti, within bracket WBSH and the choto and FWS, bracket closed, full stop. Pursuant to the said notification dated April 28, 2022, 11521, contractual, part-time employees were sought to be engaged in the newly created health units. Full stop. Mr. Dasgupta, learned counsel to next witness, appearing for the petitioners, submits that pursuant to the notification dated May 3, 2021, issued by the Ministry of Health and Family Welfare, Government of India, the central government recommended to the state / union territory governments to consider giving of preference in regular government appointments of health professionals through respective public service commission / other recruitment bodies who completed a minimum of 100 days of COVID-related duties. Full stop. Next. Mr. Shah, learned counsel, appearing on behalf of the state, submits that the memorandum dated May 3, 2021, issued by the central government, is not applicable to cases where contractual or part-time engagements are made, full stop. It is only in case of regular italics appointments of health professionals. Next.
The petitioners are not healthcare professionals as per relevant rules, my lord.
Wait. Next. He further submits on merits that the petitioners are not health professionals as described by the Ministry of Health and Family Welfare. Full stop.
And also World Health Organization.
Therefore, comma, there is no question of
Ache.
their
Stated
engagement pursuant to the notification
that's-
dated April 28, 2022. Full stop. He prays for leave to file a report on affidavit to bring the necessary documents on record. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is prima facie, italics, of the view that some preference was sought to be given to the health professionals who completed more than 100 days of COVID-related duties. Full stop. The objective of the said scheme was to appreciate the work done by the COVID professionals during the pandemic situation. Full stop. Therefore, comma, the state government may not rely upon the technicality of the appointments to be given to only employees appointed in regular, italics, government service, and not for contractually engaged, italics, engaged persons. Full stop. However, comma, before seeking to get preference under the said scheme, one has to first satisfy the government that they were health professionals under the scheme that was notified by the notification dated May 3, 2021. Full stop. Next. Let a report on affidavit be filed by the respondent number three.
My lord,
No, 4.
3 is the government of India.
4
No, my
or
lord, 2.
6.
It should be two, my lord.
2, my lord.
All right.
Additional
Respondent number
Chief
2, comma,
That will be better.
the additional chief secretary, comma, Health and Family Welfare Department, comma, Government of West Bengal, or any other authority delegated by him on the question of eligibility, italics, of the petitioners as health professionals who successfully completed more than 100 years of COVID-related duties. Full stop. Let such report on affidavit be filed by,
Yes, your lordship desire, my lord.
you tell me, how long will it take you?
2 weeks.
By July 21, 2023.
My lord, one submission, my lord. I don't know, my lord, this matter was, my lord, dismissed for default. Thereafter, on the, my lord, it was,
restored
it was,
on 20
no, no, it was restored, but I don't have the knowledge that whether the recruitment procedure is completed or not. This is
That
one
is
thing.
neither here nor there.
Lordship,
July 21, 2023, full stop. Exception, if any, by July 28, 2023, full stop. Let the matter come up for further consideration under the same heading motion, bold, on August 7, 2023.
Lordship.
Bold. Server copy.
grateful.
Item number 2, my lord, Mr. Ajay Krishna Chatterjee, my lord, senior advocate for the Union of India, my lord.
You have taken time on his ground on the last occasion. Yes, madam.
Lordship, I am for the petition, Lordship.
Yes, proceed.
I would like to submit, Lordship.
Yes. You cannot come and take time every day. I
Madam, he is
clearly
suffering
remember
from
that you
back
have
pain,
taken
my lord.
time on the previous occasions. Yes.
Lordship, this is a matter of disability pension, Lordship.
Yes.
Lordship, the petitioner has joined the Indian Army on 28th of December, 1994, Lordship, and he has served for 26 years, more than 26 years, Lordship. And there was no complaint of any kind of health issues under any circumstances. And he was later on discharged in due course on 31st of December, 2020, Lordship. Lordship, thereafter, Lordship, during his service life, he has been posted at different locations, which includes, Lordship, CIPS, high altitude, field, as well as peace stations, Lordship. Lordship, the place of posting, Lordship, will find in page number 28, Lordship.
Now the question is whether it is attributable to military service or it is
Lordship.
It is a congenital disease.
Lordship.
That is the only issue that needs to be decided.
Lordship, he has worked for 20 years. After 20 years, on 3rd of May 2013,
Yes.
he had a minute health condition due to which he was at that time, Lordship, he was posted in Rangapahar. It's in Nagaland, Lordship.
All right.
And and it is a field duty, Lordship. So
Yes.
he was working there and he had a complaint of chest pain, Lordship. He was taken to the hospital. He was admitted in ICU. Thereafter, he was taken to military hospital in Kolkata, and there he was diagnosed with ectopic right kidney after 20 years of service, Lordship. Before that, Lordship, he had no other complaints. On the last medical board also, just before he fell ill, that was held on 12th of October 2012, Lordship, which is in page number 56, Lordship will find.
1 second.
Lordship.
Page 56. Yes.
Lordship, the last medical report, it says he was in shape 1 category, Lordship. It is 12/10/2012, the third one, Lordship, from above. 12/10/2012, shape 1. And the next one was in 2013, where he was put under low medical category.
Shape 2.
Shape 2, yes. Lordship, it is S1, H1, A1, P2. That is the... Lordship, before that, in each and every medical report, yearly annual medical report, he was in shape 1 category since the day of joining, Lordship.
Now they're saying because of the
Being a congenital
because
disease.
of the medical condition, which is congenital, he is not entitled to disability pension.
Lordship, coming to the question of it being a congenital disease, Lordship, there are various decisions of the Honorable Apex Court as well as of this court also, of this Honorable Court also, that even if it is a congenital disease, if it is not diagnosed at the time of joining the services, Lordship, if it is later diagnosed, and that too after a prolonged period of 20 years, then it ought to be held that it has been aggravated by military service, because he was in service for the past 20 years, Lordship. Forever he was diagnosed as shape 1 only in 2013. Since 94 till 2013, he was perfectly under shape 1 category, Lordship. Only in 2013, Lordship, he was diagnosed with the ectopic right kidney. Lordship, if Lordship kindly allows me, I can put before you, Lordship, some case laws where some diseases, Lordship, I would like to just state, Lordship, primary hypertension.
Please give me.
Lordship.
You have your necessary instructions from the Union of India.
Yes, my lord, the instant writ petition is premature, my lord. My lord, kindly come to page 76, my lord. There is a provision for second appeal, my lord, to the second appellate committee on pension, my lord. And the petitioner has not preferred the second appeal, my lord. Directly, the petitioner came before this honorable court, my lord.
Lordship, the first one, Lordship, may I?
Yes.
Lordship, the first case law is Dharamveer Singh versus Union of India 2013. Lordship, in page 1, Lordship will find paragraph 3, Lordship, it is marked there in the first page, Lordship. The questions involved in this case are Lordship, page 2 says whether a member of armed forces can be presumed to have been in sound physical and mental condition upon entering service in absence of disabilities or disease noted or recorded at the time of entrance. Number 2 is, Lordship, whether the appellant is entitled for disability pension. This is almost a similar case as that of mine, Lordship. In paragraph 4, Lordship, I have already marked it is also 20%.
You should not mark, madam. You are not supposed to mark the copy that you give to the court.
Lordship, I apologize, Lordship. I just did it for Lordship's convenience.
All right. What you do is,
One more, Lordship, I wanted to
no, what you do is, it is not possible for me to decide sitting in writ court about the medical health of the person. In the event you prefer a statutory appeal, I will direct that the limitation period will start from the date of the order. In the event you prefer a statutory appeal, they will be disposing it off within a specified period of time. You have to first prefer the statutory appeal and then we can look into it. Ashu.
Lordship. Lordship, may I just ask one thing, Lordship? Lordship, can this writ petition be treated as a representation of the
Yes, yes.
Lordship, grateful, Lordship.
The petitioner's case is that after rendering 20 years of service in the Indian Army since 1994. After rendering 26 years of service since 1994, the petitioner was discharged from service on December 31, 2020. Full stop. The petitioner was diagnosed with ectopic right kidney, inverted commas and mother, in 2013, full stop. Thereafter, the petitioner was put in low medical category. Full stop. The petitioner was declared unfit, bolded, for employment on November 18, 2020. Full stop. Next. It is the case of the petitioner that he has always been found to be in shape -Roman 1 since his recruitment till 2012. Full stop. However, for the first time in 2013, he was diagnosed to be in low medical category. Full stop. Next. The petition, Ms. Gupta, learned counsel appearing on behalf of the petitioner submits that the condition for which the petitioner was discharged from service is aggravated by his conditions of service. Full stop. The condition of ectopic right kidney, even though congenital, was not the only reason for discharge from his service. Full stop. Had that been the only reason, then the petitioner would not have been found to be in shape -Roman 1 since the date of his recruitment. Full stop. Date of his recruitment till 2012. Full stop. Next. Ms. Shah, learned advocate appearing on behalf of Union of India, submits that the writ petition is premature since the petitioner has not preferred a statutory appeal from the order passed by. Where is the impugned order?
Lordship, page
76.
75. Lordship, it is,
By the
appellate
chief/senior record officer on January 20, 2021. Full stop. The disability pension was refused by the said order in terms of regulation -81 of the pension regulation for the Army 2008, part 1, since the disability was found to be neither attributable nor aggravated by military service. Full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view that in the event an appeal is preferred within a month from the date of this order, the first appellate authority shall consider the said appeal within 3 months from date.
Lordship, the first appellate authority has already passed the order, Lordship. It is on 12th August.
The second appellate authority would consider the said appeal within 3 months from the date when the appeal is preferred. Full stop. Next. The petitioner will be given a personal hearing, and all the necessary rules stroke regulations for disposal of the second appeal shall be considered, full stop. Furthermore, comma, the decision reported in Civil Appeal number 4949 of 2013, within bracket, Dharamveer Singh versus Union of India and others, bracket closed, bolded, shall also be considered while disposal of the said appeal, full stop. Next. The reasoned order passed in the appeal shall be communicated to the petitioner within 2 weeks of passing thereof, full stop. Next. With the directions aforesaid, WPA 7795 of 2023 bolded is disposed of, bolded, full stop. Next. Since no directions for affidavit, next. Server copy, certified copy. Kindly come this side. Why are you going that side? You are for the petitioner. Please come this side. Why are you moving?
I am the petitioner. My lord, grievance of the petitioner, my lord, against the transfer.
Yes.
To transfer is the incident of service, my lord. This is the second round litigation, my lord.
Yes.
My lord, initially, your lordship passed the order.
What is the malafide?
My lord, for consideration, but that is not.
Yes, what is the malafide?
My lord, because the petitioner's grievance is that he's the main caregiver. Caregiver of the family, that is not considered. That is the malafide. And he was in a hard area, Kashmir, for six years, but without complete the Kolkata,
On the microphone.
without completing the minimum 3 years, he has been transferred. And their case is not, there is no individual treatment, but there is individual treatment, my lord. My lord, kindly go to the order of your lordship, my lord. Page 35, my lord. Well, the petitioner grievance is that he has been transferred from the
All right, I'll read it. 1 second.
transfer.
Come to paragraph 9 of the reasoned order.
This is not the correct, my lord. That's why, my lord, at para 3 of my writ petition, I have explained para 3. Para 3 of the writ petition, my lord, I have explained how he worked, my lord.
All right, let them
Several times he was worked at,
let them explain this paragraph in their report.
and yes, my lord.
Ashu.
Lord, may I just say on?
Yes,
This is the second round of litigation.
yes, there is no doubt about that.
This is not an ordinary transfer. This is a transfer of a discipline force. And my lord is aware the Supreme Court has, on this aspect of a transfer of a discipline force, has said that there must be some relaxation to the authority for arm twisting. That is the word expressed by the Supreme Court. But some relaxation. Now, thirdly, is not the petitioner is individually transferred. The entire battalion is transferred. And the transfer order is of 24th May 2021. And we are in July 2023. And thirdly, after your lawsuit's order, when a reason order has been passed.
Yes, I'm looking at paragraph 9 of the.
Yes, I'm just on this.
Yes.
When a reason order is passed and exactly it fell from my lord, then unless there is malafide, whether a reason order can be set aside or can be questioned, because lordship is not sitting in appeal. It's a question of purely judicial review. And there is no malafide because he has worked for 20 years in Calcutta.
That is what you have to explain by a report on affidavit, because his statements at paragraph 3 are at variance with your finding at paragraph 9 of the reasoned order. So that is what you're required to explain. From where are you coming to this finding? Yes. From where are you coming to that finding?
He has said that out of 26 years, he has worked how many years outside?
Yes, you have to see it. Because
para 3 your petitioner states that your petitioner was appointed as an employee under border security force.
The second part of the paragraph, you see.
Then last is, it is stated that your petitioner has discharged the duty with the utmost honesty and punctuality within fullest satisfaction of the authority.
So it is not a question of only 5 years outside. He has said from when to when. So you have to explain this on report, how you came to that finding.
Usually, your lordship.
And also para 5 of the reason order, my lord, caregiver is not properly explained, my lord. Whereas it respectful compliance, honorable court, my lord, dated 3rd such and such. So video conference, the headquarters director.
Yes, nothing happens in paragraph 5. Nothing turns on paragraph 5.
As a caregiver, it is.
Nothing turns on that at all, but paragraph 9 has to be explained.
Yes, yes.
Ash. By an order dated January 3, 2023. This court directed the Inspector General within bracket Commandant bracket closed comma BSF to consider the representation of the petitioner against his transfer from Digberia, Madhyamgram, Kolkata to Nolkata, Tripura. Full stop. The petitioner is working with the border security force within bracket BSF bracket closed full stop. Next, pursuant to the said order passed by this court, a recent order dated February 16, 2023 is passed by the DIG within bracket Commandant hyphen ESTT bracket closed full stop. Such recent order is impugned in the present writ petition. Full stop. Next. By the recent order, the authorities held that the petitioner is required to move from South Bengal frontier to Nolkata, Tripura, since the entire unit has been directed to move to the new location due to administrative exigency. Entire unit hyphen 179 battalion, BSF due to administrative exigency, full stop. Therefore, the personal request of one member of the unit to remain in a particular location could not be considered, full stop. Furthermore, it was held that after going through, furthermore, to the new next paragraph. Furthermore, it was held that after going through the entire service record of 26 years of the petitioner, it transpired that petitioner has served in the home state within bracket West Bengal for more than 21 years, full stop. Since service at BSF is a transferable job, the petitioner's request to remain in the home state after serving more than 21 years thereat could not be considered, full stop. The manpower could not be kept at static locations, full stop. Next. The learned ASG appears on behalf of the Union of India, full stop. Next. Mr. Mondal, learned counsel appearing on behalf of the petitioner submits that Such recording of facts is entirely incorrect since the petitioner has been posted in several locations all over India, including a hard posting at Kashmir frontier. Full stop. Therefore, there is no substance in the finding that the petitioner has been posted in the home state for more than 21 years. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing the respondent number 5 stroke DIG within bracket commandant bracket closed.
Not DIG.
Respondent number 4. Respondent number 4. DIG commandant.
This improved order has been passed by the DIG commandant establishment in New Delhi.
Yes, but he has to file a report because he will be aware of the facts. Or any other authority delegated by him to file a report on affidavit stating the basis on which the statements made in paragraph 9 of the impugned order has been made. Full stop. Have been made. Full stop. Next. Let such report on affidavit be filed by July 21, 2023. Full stop.
Kindly give 3 weeks time.
By July 28, 2023. Full stop. Next. Exception, if any, by August 4, 2023. Full stop. Next, let the matter appear for further consideration under the same heading motion, bolded, on August 7, 2023. Bold. Server copy.
Grateful.
Yes.
This is my application, Your Lordship. Before I trouble Your Lordship with the papers, I'll just recapitulate whatever I'd submitted on the last occasion, my Lord. I'd not completed. My case, my Lord, is with respect to the petitioner being a CISF officer working for the Central Industrial Security Force. My claims were with respect to the fact that
Yes, you were saying that an opportunity of hearing should have been given.
was one of my contentions, my Lord, with respect to the fact that I was not, I was forcefully made to work beyond 8 hours, contrary to the circulars, and the financial benefits that I would be entitled to based on the same were not paid to me. So I advanced 3 contentions, my Lord. The first was, before that, I'll just indicate to Your Lordship
The
that
opportunity of hearing was not given, the circulars were not properly appreciated, and the impugned order is vague on its face.
only one other contention, my Lord, which I had advanced. Of course, I didn't have the chance, I didn't have the time to flesh that out, my Lord. I did not, in fact, put it, was that,
Because 3 contentions.
yes,
you put
I
down,
would have, my Lord.
contentions have been recorded.
No, I'm coming with that today, my Lord.
Saying that one more contention has not been recorded.
No, I mean to say, my Lord, that I'm bringing it before this court today. I had not advanced it on the last occasion. Was that the impugned order takes into account certain factual aspects. With respect to the factual aspects, the first contention that I have, my Lord, is that I should have been afforded an opportunity to counter the same. And the second, my Lord, is that once those factual assertions have been made in the impugned order must also take into account the source of those factual assertions. That is, substantiate the basis of the same. With respect to the opportunity of hearing not being afforded to me, Your Lordship was of the opinion that because the order which had directed me to go before the respondent number 4 in a prior writ application, my Lord, had not recorded that I must be given a personal hearing. Therefore, it was incumbent upon me to file for a clarification, which was my failure. I did not do it. It should have.
You were trying to explain to this court the meaning of the order, That you were seeking to do on the last occasion, as far as
My
I
lord,
remember.
yes, I have.
What this court intended by passing that order, which I thought was a little far-fetched. When the court was telling you that this is the intention, you are trying to tell the court what the intention of the court's order
No,
was.
your lordship
Anyway,
is-
please make your
Your
submission.
lordship has taken me amiss. My submission was,
That is what, at exactly 10 to 15 minutes you submitted on that.
then your lordship would
What the court intended to mean.
Your lordship would kindly allow me to clarify on that in that case. I went and I also read up a little on that. So perhaps I'm in my humble submission, I'm a little better equipped now. So I'll probably frame it a little better.
Tell the court what is the intention of
No,
the
no,
court.
that,
It was a
no,
little,
that wasn't my
isn't
intention.
the scope of your, it shouldn't have been the scope of your submission. Anyway,
Or my brief for that matter, your lordship. That wasn't my intention. With
it
res-
wasn't your intention to tell the court.
no,
Because that's what you were trying to say, that this is what the court meant and this is what the authorities should have done. That was exactly the tenor of your submission.
in that case, your lordship would allow me to withdraw that submission. I must, in that case,
Nowadays, everything is there on live screening, so you can go and see what.
no,
your
I
submission
have actually, I've taken the, okay, I've had the occasion to,
It's better for the court also. It is better for the lawyers also. Everything is there
definitely,
on record.
my lord.
So now you also don't have to take what the court is saying as gospel truth.
No, no, lordship, with respect to the point of no opportunity of hearing being afforded, I would submit today, my lord, that it was not there in the order. I did not ask for a clarification, which ideally I should have. I did not do so. But with respect to the order not having a direction with respect to the opportunity of hearing to be mandatorily provided to me, I say this, my lord, that
It's better for you to file a short notes in your case, because somehow I feel what you will be submitting and what the court will be recording, there might be a disparity.
no, no,
You will say that this is not intended. In your case, you give me a one-page note
I shall
so
do
that I can understand exactly what the tenor of your submission
I
is,
shall do that, my lord.
so that it is in writing.
I shall do that. I also apologize, my lord, if that's been
So
the.
that is what I intend to do, because there is no point in making submissions and letter withdrawing, because it's a waste of judicial time to my mind.
It is. I did not have, I was not equipped with the law, my lord. I have come back.
You bring your notes, I'll consider your case. You bring your notes and consider it, because.
But would it
so
be your
much-
lordship's pleasure to, in that case, allow me to argue the other points, my lord, which
No,
I was
not
in the.
today. Not today, because I will again not be able to understand what you're saying or not be able to record properly what you're saying.
Lordship, but
You
in that
bring
case,
one-page
I'm
note
not
and then
submitting,
I'll
but in
consider.
that case, my lord, I must clarify and apologize. And this has nothing to do with my brief, my lord. I apologize to this court if that's the impression that has gone out.
No,
That
you
wasn't
bring a
my
one-page
intention.
note.
I shall do
Yes,
that.
I cannot
I shall
allow
do
you
that.
any more time today. You bring,
Very
you tell me how soon will you be able to bring?
As your lordship.
Just formulate the points.
I'll make
Yes,
a one
very
pager.
You tell me, I'll keep
Lordship
it.
allows me to come back anytime next week, my lord.
17th. 17th?
Would it be your
Because
lordship?
I only take new motions 2 days a week. So come back on the 17th.
Then in that case, I'll come back this week itself, my lord, whenever your lordship allows.
Then come back on the 11th, Ashu. Mr. Nayak, learned counsel appearing on behalf of the petitioner, is permitted to file a short notes of his arguments on the adjourned date of hearing, full stop. Next, let the matter appear for further consideration on July 11, 2023, bolded, under the same heading motion, bolded. Serve a copy.
I'm deeply obliged. Also, my lord, I'll extend my apology one more time.
Right. That's all right. It's better it's in writing. You will know what you have submitted. I'll know what you have submitted.
No, but possibly, my lord,
Because if you tell the court what the intention of the court's order was, then it might be going beyond your brief. Probably.
it was, my lord. Which is why I was not making that submission.
He is a
again.
constable. He is a constable. The better should have been that he should approach the labor court. It is an individual dispute, not the public dispute. So the remedy lies elsewhere. And there is a grievance settlement authority. The reason order has been passed as an extension of the grievance settlement. But the question is that there is grievance settlement authority. He should go there.
The point of alternative remedy.
Yes,
on the
that is
next
there.
occasion.
That is always there, my lord. But anyway.
You take whatever points you want to take.
You're obliged.
My lord, next matter, I'm appearing for the Union of India.
My lord, this is my application. My lord, this is the case of a sepoy's widow. The sepoy actually died in 2020. We made applications, we stated everything, gave all the papers. And on the last occasion, your lordship kindly directed that they should file a report. The widow is not getting anything for the past 3 years. And she is absolutely in poverty, my lord, because the husband has died and she's.
Yes, the tribunal is not functioning.
Yes, yes,
It is
yes.
not
No,
functioning.
no, no.
My learned friend's submission is the tribunal is not functioning, my lord. My lord, your lordship was pleased to direct me to take instruction on that, my lord. My lord, I have taken the instruction. On 30th July, the tribunal took a matter on video conferencing, my lord. Our cause list is also attached with
30th June.
30th June, my lord.
There is no presiding officer in Calcutta, my lord. I don't know whether that was an extraordinary matter or not.
All right, Mr. Chakraborty, it is only the urgent matters that are being heard.
Yes.
Now, are you going to undertake before this court that the case of the petitioner's case will be considered and disposed of within a time frame? Otherwise, I have to get into the merits.
Yes, my lord, kindly allow me to take instruction, my lord, regarding this matter.
Because
Without
if you
instruction,
want- if you
without
want
instruction, I
the
cannot.
tribunal, them to go before the tribunal. Now, this widow also cannot be rendered remediless year after year.
For 3 years, my lord. 3 years from 2020.
The petitioner's husband died on
2020.
March 23, 2020.
Absolutely, my lord.
Now, more than 3 years have passed.
My
And
lord,
there's no
actually-
presiding officer, my lord.
Actually, I'm telling your lordship.
Please speak on the microphone.
My lord, kindly see paragraph 17 of the writ petition.
Yes.
Paragraph 7 of the writ petition.
All right.
Okay, confirm.
Lordship, I'm appealing for respondent 4 and 5. Yes, go.
Yes.
Because
4
on
and
2nd
5.
September.
All right. You don't have anything much to say.
No, he doesn't.
Let the answering respondent submit.
My lord, on 2nd September 2020,
Mhm.
the application was filed, my lord, to grant the pension.
So instead of March, from September,
Yes, but no,
it is pending.
no.
Instead of
September
March 2020, it's from September
The
2020.
reason which was not paid here with the endorsement, with the endorsement that the name of the family pensioners was not endorsed in the pension payment order.
So now that's
That's the
dispute.
reason. That's the
So
reason.
that is the dispute that has to be adjudicated.
Yes, ma'am.
So this is neither here nor there.
Yes, my lord. There's a reason, my lord, what I am submitting there.
Yes, you tell
So
me.
I take please kindly allow me to take the instruction on that.
Because
Well, I've given all the papers.
if you undertake before this court, or if you submit a written instruction saying that this matter will be taken up and considered within a particular time frame, I have no intention of taking up every matter and burdening the court where tribunals are available.
Yes, my lord. Yes, my lord. My lord,
Well, there is no
that,
there is no presiding officer in this particular tribunal. I do not know whether
Someone is in charge. And
Yes,
someone
yes.
is taking up urgent matters.
But this will not be.
I'm trying to resolve the dispute. Please
Great.
give some time. Ashun. Mr. Chakraborty, learned counsel appearing on behalf of Union of India, hands over written instructions in court today, full stop. Such instructions are retained with the records, full stop. From instructions dated June 30, 2023, it appears that urgent matters are being heard by the Armed Forces Tribunal within bracket regional bench bracket closed, Kolkata, full stop. Next. To the mind of this court, the case of the petitioner is an urgent one, since she has not been receiving any family pension since the death of her husband on March 23, 2020, full stop. Her husband was a retired sepoy in the Indian Army, full stop. This court cannot be unmindful to the hardships suffered by a widow whose husband rendered service in the Indian Army, full stop. Next. The issue seems to be that the petitioner's name was not
In the payment
included
order,
in the
pension payment order.
pension payment order within bracket PPO of her husband. Full stop.
That has been resolved. We have given everything now.
The petitioner made an application for payment of family pension on September 2, 2020, full stop. Such a dispute has not yet been resolved and no payment is being made in her favor. Full stop. Next. Considering the submissions of the parties and also the provision under the Armed Forces Tribunal Act, 2007. This court is of the view that justice will be subserved by directing the respondents stroke Union of India to file a written instructions in the matter regarding the time frame within which the petitioner's case may be disposed of by the authorities from the date of filing of the same. Full stop. Next. When can you get the instructions?
My lord, next Monday and Tuesday, I will not be here. My lord, I have
You tell me, you just tell me a date,
Fix my-
because from
6 weeks.
2020 she is waiting. She can wait for 2 more weeks. There is no.
It is a pro bono matter for me, my lord. My lord, not next week, following.
Week after, all
Week
right. Let the matter come up for further consideration under the same heading motion, bolded on July 17, 2020.
So that she's in an extremely wretched condition. That's the reason I am appearing in this matter for her. She's got no money, nothing, my lord. Absolutely.
That
in
is
rags.
why, despite there being a tribunal, this court is seeking
I
to
know,
entertain.
that's it.
My lord,
That's,
Everyone is trying to help.
I know, that's the
20
humanity factor, exactly.
She has not approached, she has approached now. We are all trying to help her.
Yes, I know, my lord. That's it.
My instruction was, my lord, if the petitioner files an application stating there in the urgency of the case, that will be considered and
You will have to tell me by when.
yes, ma'am. Yes,
There has to be some pressure on you.
yes.
Grateful, my lord, extremely
Yes.
grateful.
That is why I said from the date of filing within what is the time frame within which
Yes, yes.
you will be disposing it of.
Yes.
Extremely grateful.
Six, I beg copy for the petition number.
What happened, Mr. Chatterjee?
Not possibly, my lord, I have a good cause but a bad case. But the issue is, my lord, with the Eastern Railways. My lord,
It's not maintainable.
yes.
How can it be maintainable
No,
here?
I'm not on the point of, my lord.
You are not, she is.
My lord, yes, absolutely. I have stated also that the Central Administrative Tribunal ought to be have.
He has approached the tribunal prior, so it is a service matter. Dispute relating to his.
I'm on the point of national justice, my lord, nothing else, my lord. The issue is, my lord, that I have joined service in 1967.
Very good.
In the year 2002, I take VRS, my lord. Now prior to that, there was a disciplinary proceeding stating that I did not disclose my correct date of birth. Now,
But why are you going in the merits?
No, I'm not. I'm coming to that, my lord. In the disciplinary proceeding, they have stated that the correct date of birth is what I have stated. Now, they did not rectify my date of birth. Now, by this passage of time, my lord, I would have got a 20% increment in my pension.
Very good.
That is my only prayer, my lord.
Have you filed before the CAT?
No. I had filed in
There are previous
1995.
applications before the CAT.
He's pending.
No, that was
not
disposed in
pending. I mean, he
1995.
has gone to the CAT. That is.
And then what happened to that?
Those are disposed of.
And disposed of in my favor. That yes,
Yes, now you know what to do. Why have
I
you
had
filed
preferred an
petition?
application, but 2 application representations are pending before them. Unless and until they come up with a reasoned order, I cannot approach the court. What is the fate? Because if they consider my application in the affirmative,
Under Article 227.
26, no.
Yes, under 226 can you do it?
No, extraordinary powers are there.
Kind of said
Extraordinary
227.
powers
Under
are
Article
there.
226, can you challenge?
In
In my mind, I was thinking of a different article. So
When there is no order, he can challenge that before the CAT. If he's aggrieved by that also.
But extraordinary circumstances, 226
No,
can be
Mr.
entertained.
Chatterjee,
Even
not
if
like-
alternative remedies are there.
Mr. Chatterjee appears for the petitioner
But
and submits that despite applications being pending before the Central Administrative Tribunal, the same
we have stated that.
have not been disposed of till date. Full stop. Next, Mrs. Alam, learned counsel, appears on behalf of the Union of India and submits that since the petitioner is an employee of the Eastern Railways, was an employee of the Eastern Railways, full stop, no comma. The writ petition is not maintainable, full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view that the Central Administrative Tribunal is the court at first instance under the Administrative Tribunals Act, 1985, full stop. The court takes this view relying on a judgment. This view relying on a judgment reported in blank L. Chandra Kumar, full stop. Next. In the light of the discussions above, WPPA 13271 bolded of 2023 is dismissed bolded. However, not so quickly. It is made clear that this court has not gone into the merits of the writ petition. Full stop. The parties will be at liberty to take appropriate steps, if so advised. Full stop. Next. Since no directions for affidavit, server copy certified. Before I can pass orders in his favor, he is saying grateful and he is finishing it off.
Well, I've stated that the alternative forum is there.
But I have to say that in my order.
Grateful.
I beg to appear on behalf of the petitioner.
Your Lordship, I'm for the respondent corporation.
In this matter, petitioner was retired from service 31st July 2021 from the post of the Cashier. Cashier. Now the petitioner claimed for the pay protection of the acting depot cash superintendent. As when during the course of his service, he has been acted as the post of the depot cash superintendent and discharged the duty of the depot cash superintendent. And at the time of the retirement, he has been superannuated at the 67,800 at the pay scale of the depot cashier. But he has been charged by the additional duty till 2015 to 2021 for the work of the, my lord, the depot cash superintendent.
And you got the salary at that scale.
That scale. My lord, now the petitioner claim that his pay protection and the differentiation of pay of the, my lord, the depot cash superintendent. He claimed by the promotion during the course of his service, my lord, his promotion has not been considered due to the withhold of the increment. He came before this honorable court that thereafter the area salary has been released by your lordship. Now the question is,
did you get anything?
Yes, I have, my lord, paid. Now the petitioner again claim that the scale of pay of the, my lord, the 80,500, that is, my lord, I mean, annexed the copy, that is the acting depot case, acting depot cash superintendent scale.
Show me the scale of pay.
Kindly come to the page 37.
Yes.
Page 37, kindly last bottom 2 lines.
Serial number?
Serial number 32 and 33. 32, my lord, the post of the depot cashier, that is 67,800. Now, my lord,
Wait, 67,800.
next.
How will I know it is the scale of depot cashier?
My lord, the kindly at the top, my lord,
Top, I cannot see anything.
3,200, my lord, his basic.
Wait, where at the top? I cannot get anything. 3,200 is the basic. Yes.
And 3,900 is, my lord, the depot cash superintendent basic.
3,200.
3,200 by the cashier, depot cashier.
Where? How can I tally this? With what am I supposed to tally this?
Tally, my lord, the kindly come to. I have annexed, my lord, the page, kindly come to the page 51. Differentiation of pay and rectification basic. I have the copy of the tabulation sheet.
51.
51.
I cannot understand.
Last basic was, my lord, 67,800, and last, my lord, the acting depot cash superintendent basic is 82,900.
No, from 51, all this is not possible to understand.
And other.
From 51, I cannot see all this.
My lord, the 51, my lord, this is the tabulation sheet, my lord, prepared by the petitioner.
First, you tell me that this is the basic pay for depot cashier at page 37. From where will I get it?
My lord, kindly get it. Last, his page 19. Page 19, his, my lord, the salary statement.
Page
19.
19.
19.
All right.
19, my lord, that his prominent fund such as the leave investment. And his basic was, my lord, that 58,400 plus last drawn plus calculation, and total is 1,20,000. The gratuity 12 calculation is 6152.
Where is the basic?
Basic, my lord, the
You go through the papers and come back. You cannot look into the papers now. Please come back. Come back on the 17th. Act a line. It is submitted on behalf of the petitioner that despite discharging service from 2015 till his retirement on July 31, 2021 as depot cash superintendent, the petitioner is sought to be given the retirement benefits as a depot cashier and not as a superintendent. Cashier or superintendent gulo ke italics se korun. Full stop. Unar namta diye deben, appears on behalf of the petitioner. Ms. Datta appears on behalf of West Bengal State Transport Corporation within bracket WPTCL, bracket closed, full stop. Next, let the matter appear for further consideration under the same heading motion bold on July 17, 2023.
Grateful, Your Lordship.
This matter I will be praying for an adjournment for 2 weeks, my lord.
My lord,
You want
Adjournment for 2 weeks.
only?
my lord, I beg to appear
There's a
for the
bereavement in
respondent
the family.
ACL, my lord. Only one.
Sudeep Sharkar is appearing. There's a bereavement in the family.
My lord, only one humble submission, my lord. I have been assigned with this matter, but there is no copy lying with the department as well. They have not received it yet. My lord,
I
I
do not have
also
any
have.
instruction over the issue, but I will inform the advocate and record.
I'm not passing any order.
No.
My lord, if a copy can be given to me directly, that can work as well, my lord.
Good for you. If they don't give it to you, you take this point on the next occasion. Good for you. 24th.
Grateful to your lordship. Much obliged.
My lord, 9, my lord, I am for the petitioner.
My lord, I'm sorry, my lord. 24th, I have a difficulty, my lord.
He's there or has he got? I'm
My lord,
keeping it on the
I-
25th. I'm keeping it on the,
I'm
will you
just
please
informing.
tell him.
My lord, Stato, your lordship kindly come to page.
First, let me see the
Yes.
service. Panel must have changed.
Yes, my lord.
8th of June, you have served on the GP's office. You're appearing for this day?
No.
Panel must have changed after you have served it on the
No, my
GP's
lord.
office. On
Then your
8th of
lordship-
June, you have served.
Your lordship then kindly fix the matter on Friday. I will inquire who will in this
Keep it
matter
next Monday.
next Monday.
Yes.
Or my lord, next Wednesday, my lord.
No, either Monday or Tuesday, you tell me. Because new motions, I take these 2 days. I can keep it on the 17th. Ashin actor affidavit of service filed in court today be retained with the records. Full stop.
Amta diye din.
Despite service, no one represents the state respondents. Full stop. In such circumstances, the learned counsel appearing on behalf of the petitioner is requested to serve another notice of the writ petition in the office of the learned additional government leader and file proof of service on the adjourned date of hearing. Full stop.
Learned government leader.
Office of the government. You have served the GP's office, but it is on 8th of June. That is the difficulty.
So your lordship take the matter on next Tuesday.
No, 17th, Monday. Let the matter appear under the same heading
Alert.
motion on.
11th, my lord. Next Tuesday.
That is what I was telling you.
Next Tuesday.
When I said that, you said Wednesday.
Yes, my lord. Because my lord,
On
Monday and
11, 2023.
my lord, Monday and Tuesday, my lord, I am busy with the appeal matter. That's why.
That is why I'm telling you 17th you want to come back or 11th?
11th. Let it be on 11th.
It's affidavit of service.
My lord, affidavit of service may be kept on record.
the affidavit because the petitioners are challenging the insertion of a cut-off date in P2. Would you kindly come to page number page 35. The question of movement of pre-revised scale number 19 for the officers belonging to the state constituted service other than West Bengal Secretariat services has been under active consideration of the government for some time past. After careful consideration of this matter, the government has pleased.
State matter led by Mr. Ujjwal Mukherjee. He is in like before courtroom.
Pleased to decide to allow to move the officers belonging to the West Bengal State Constituted Services other than West Bengal Secretariat Service, blown in scale number 16 to move to the pre-revised scale number 19, that is rupees 14,300 to 4,400, 8,300 to payment number 5 with GP of 8,700 as per ROPA 2009. After completion of 25 years of service, in case they do not come under the existing quota within the said period and completed the last 3 years of service in pre-revised scale number 18 and also subject to the following conditions. A, such movement will be purely non-functional. B, the eligible officers may hold the same as personnel to them without any change of designation and nature of duties. They fulfill all this. The only thing is that
So now from scale 16, they have moved to scale 19.
90, already they have moved, they are retired. Now, Lordship, the norms for such movement.
And it's a non-functional movement.
I am only aggrieved by this clause 3, the clause 4. The norms for such movement regarding APR will be as per para 3.30.6 of the recommendations of Fifth Pay Commission in part 2 of volume 1. Necessary screening will be done by the Departmental Promotion Committee. 4. The order will take effect from 1/12/2012. This is what I'm aggrieved about. We are prior to that, and this order has been effected on this. Our only
Now,
submission.
from when were you given the promotional benefits?
These benefits are
Pay
given.
fixation, not
Pay
promotional.
fixation when we were in service. This petitioner
Tell me.
Yes. Yes, my lord, they were retired in paragraph number 2. I have taken this. Said that all affected members of petitioner number 1, including petitioner number 2, 3, joined the group. Now, date before they labor service and West Bengal, and they retired on different dates before 1/12/2012. Sometimes past prior to this.
So the effective date of this order is 1/12/2012.
12.
They have retired before that.
They have retired before that.
Then how can they get benefits of this order?
Now, this order, I'm challenging this insertion of this particular cutoff date is unconstitutional. They cannot create two classes among the beneficiaries of the government, particularly the retirement dues and other pensionary benefits when it is given. So far, the law operating.
Possible, Mr. Chatterjee.
Lordship.
Yes.
This writ petition is not maintainable, my lord. Kindly consider paragraph 2. They are all
government employees.
All government employees, my lord.
Lordship, this maintainability issue, Lordship, possibly here. I am not on that. I am challenging the law.
All government employees.
Insertion of the
and this is
cut-off
a
date.
service matter, my lord, within the meaning of
Is it-
section 3Q1.
Cut-off date. And Lordship, if your Lordship wants, I will satisfy your Lordship regarding the maintainability.
Paragraph 2, page 3. The petitioner states that all the affected members of the petition number 1, including petition number 2 and 3, joined as Group A officers of the government of West Bengal in pre-revised scale number 16 as member of the state constituted service, namely West Bengal Commercial Tax Service, etc. Now, kindly consider these are all government servant, my lord. under the state.
Admittedly, they are government servants.
And this
Why have you filed the writ petition?
Now, Lordship, the only concern is that insertion itself is violative of Article 14.
Maybe.
When
be
there is a
challenged before the West
constitutional
Bengal
challenge,
Administrative Tribunal.
when the challenge is
You have
regarding
to-
the law
you have-
itself,
This is what you are challenging, your right to get a revised pension. You have to go before.
the right to get a
tribunal.
revised pension, Lordship, according to me, my submission is that,
And you are challenging a notification of 2012.
yes, Now, challenging the notification of 2012, Lordship, so far these notifications are concerned when it is curtailing the constitutional right, Lordship. This
Of 2012,
delay,
you have come in 2023.
Lordship, if it is detected,
Anyway, these are government
now,
employees. You have to go
government,
before
now
the tribunal.
only one thing, Lordship, kindly appreciate one thing.
Trying to.
This cannot be done by the tribunal because I'm challenging the validity of that insertion of the cutoff date.
He has not challenged
Now,
the
so
violation
far-
of any provisions of West Bengal Administrative Tribunal. Only
So
that
far,
is
this
restricted.
particular insertion of this particular
That's all.
cutoff date is concerned, this is the law which is operating in the field. The law is under challenge. I am not going to get any benefit out of this. The challenge, my challenge is on this particular law. How could this cutoff date be inserted in this?
Yes, that is their policy decision.
Now,
Anyway, you have to go before the tribunal, Mr.
Now,
Chairman.
Lordship, kindly give me some time. I will satisfy your Lordship on maintainability. Once this maintainability issue is raised by them,
They have.
they have raised. Lordship, give me one day. I will satisfy your Lordship on
Ashutosh.
this point that this is maintainable.
First of all, you come in 2023, challenge a notification of 2012, and now you are all government employees.
Give me one day.
Even
time.
on merit, it's inordinate delay.
Lordship, that possibly that will not
Not
come
at
on
all.
the way.
I'm sorry. The petitioner's challenge, a memorandum dated December 28, 2012, issued by OSD and EO, Joint Secretary, to the Government of West Bengal, Finance Department. The petitioners are all retired employees of the Government of West Bengal. This petition has been filed on May 16, 2023. Full stop. 3/2023. Full stop. Next, Mr. Rai Mukherjee, Learned Counsel, appearing on behalf of the state. Respondents submits that the writ petition is not maintainable in view of the provisions of the Administrative Tribunals Act, 1985. Full stop. Next. Let the matter appear for further consideration under the heading motion holding on the issue of maintainability. Full stop. Prima facie, italics, this court is of the view that the subject matter of writ petition comes within the purview of the appropriate tribunal under the Administrative Tribunals Act. Next, let the matter appear for further consideration under the same heading motion bolded on July 17, 2023.
Grateful.
Serve a copy.
My lord, I'm appearing for the respondent bank.
Yes.
12, I beg to appear on behalf of the petitioner and my affidavit of service. My lord, the petitioner was the assistant manager under probation of the Muchia branch of Punjab National Bank, Lordship. An allegation of financial embezzlement was brought against him in 2021. Lordship, before any charges were filed against him, Lordship, he returned the entire money on his own volition. Thereafter, Lordship,
Very generous of him.
Lordship, 3 persons were
Extremely generous of him.
the three persons were involved. Lordship, he is the person who came forward and returned the entire money. He begged, borrowed, did not steal anything, but returned. Lordship kindly takes up the inquiry report for once, my lord. That is at page 38, annexure P5. Kindly turns to page 40, my lord. Lordship, these are the list of my lord is at page 40. These are the list of transactions, Lordship, where the embezzlement happened. Lordship will see the last two columns, entered stroke posted by and verified by. Lordship, it is the transaction number is followed by PS. Lordship, that is the petitioner, his serial number. NJ is the manager of the branch manager of the bank, Lordship. Lordship, several other transactions were entered. Lordship kindly takes up page 36 once. I'm sorry, my lord, page 41 once. Lordship, serial number 32 onwards. Lordship will see PS, that is entered stroke posted by, and SC is the code of one Sushil Chandra Bosak, Lordship. He was the cashier of the bank.
All right, I've seen that.
There were three persons.
NJ and SC.
Yes, Lordship. Lordship now kindly turns to page 44. This is the inquiry report that was filed. The final, considering, Lordship, the second paragraph, which is in bold capitals, page 44, my lord.
Yes.
Considering all the points, I recommend that in the subject case, both staffs are equally liable for fraud. So both must get same punishment without any bias to anyone. This is the report filed by the inquiry officer, Lordship. There were three persons involved. The report says there were two staffs, and Lordship, same punishment should be meted out to both of them.
Yes.
Lordship now kindly turns to the next page, that is annexure P6, that is the final order that was passed.
Yes.
Lordship, at page 48, if my lord takes up page 48, Lordship, the petitioner before my lord was charged with a major penalty. Lordship will see the paragraph at page 48, 4 lines from the bottom, Lordship.
Yes, I've seen major penalty of removal from bank service.
Yes.
Yes.
Lordship, the other persons, the person whose initial was entered as NJ, Nusrat Jabin, who was the branch manager, she was let off with a minor penalty. And the second person who was involved, he was not even charge sheeted. Against this order, Lordship, the final order, the petitioner has preferred an appeal. Lordship, that appeal was preferred in on January 31st, 2023. The period for disposal, that is, the appeal was to be preferred within a period of 45 days. I am within that 45 days.
All right. What happened in the appeal?
Lordship, nothing has happened thereafter. The appeal has been kept pending since then. And Lordship, considering the conduct of the bank and the inquiry that has, and the treatment that has been meted out to the petitioner, Lordship, he is not very confident of any success in that.
First, this has to be disposed of.
My lord. My lord, and secondly, if my lord may comes to their appeal, my lord, I do not know why it is not numbered, and my lord, from their record, it is not evident that when they have filed the appeal, they have only taken an averment to that aspect that they have filed the appeal on 31st of January 2020.
Today, are you ready with the instructions? Is the appeal pending or not?
Lordship, the appeal is, Lordship, on that I have to take
instructions.
My lord, so far, since this record are produced before the court, your lordship, I am assuming that whatever they are stating so far as the appeal that.
You would have to tell me that when has it been filed, since when it is pending.
My lord, that instructions I'll
the
take.
period of disposal, 3 months.
My lord, the period of
90
disposal
days.
is 90 days, 3 months, your lordship, and they have filed the appeal. As per them, they have filed the appeal within 46 days.
You tell me when they have filed.
My lord, I'll come back within 2 to 3 days as your lordship pleases, my lord.
It is the grievance of the petitioner that he has been unfairly removed, bolded from service, whereas the co-accused have been either let off with a minor penalty or without being charge sheeted at all, full stop. The petitioner was an employee of the Punjab National Bank, full stop. There was inter alia an allegation of defalcation of funds against him, full stop. It is submitted on behalf of the petitioner that the funds that was alleged to be misappropriated by the petitioner and his co-accused have been refunded by the petitioner to the bank, full stop. Next, the inquiry officer by his preliminary order opined that that two of the co-accused should be subjected to similar punishment, full stop. However, in the final order passed by the disciplinary authority on December 16, 2022, the petitioner was removed boldly from service, whereas the other co-accused, stroke the branch manager, was let off with a minor penalty, full stop. Next, learned counsel appearing for the petitioner submits that the disciplinary authority acted with arbitrariness and malafide intention, full stop. The said order of penalty was challenged by way of a statutory appeal. It is submitted that the period of disposal of the statutory appeal has expired, full stop. However, there is no adjudication of the said appeal. Adjudication of the said appeal, full stop. Next, Ms. Raichaudhuri, learned counsel appearing on behalf of the bank, submits that necessary instructions are required to be taken on the issue whether the statutory appeal has been disposed of within time. Full stop. Next. Considering the submissions of the parties and the materials placed on record, this court permits Ms. Raichaudhuri to bring the necessary instructions on record on the adjourned date of hearing. Full stop. Next, let the matter appear for further consideration under the same heading motion. How long will you take?
Only 2 to 3 days.
On July 17, 2023. Motion to bold July 17.
I'm grateful to you, Lordship.
I'm grateful.
Lord, I'm for the petition in this matter. This is my affidavit of service.
I have responded.
Now all good, Mr. Arifin?
Yes, madam.
All
He's also recovering, my lord.
in the home front? All good.
My Lord, so far the matter is concerned, my lord, the petitioner's father and grandfather had the property which was taken by the ECL, Eastern Coalfields Limited. My father was nominated as the person under the land loser scheme, my lord. Well, till then it has been pending. I draw your lordship's attention to page 32 for once. Page 32.
When was it taken?
In the year 2005, my lord. till then, my lord, it has kindly take. I'm placing it to your lordship. My lord, kindly take page 32.
Yes.
My father's name is Dhiraj Dash.
Yes.
Now, my lord, kindly come to page 38. That is the last communication came from the side of the authority.
Page 35.
38, my lord. Kindly take page 38. As of 19th of February 2015.
Yes.
My lord, the subject is employment proposal against land loser scheme. It was addressed to me as well. My name is written above. This is Dhiraj Dash. This is my father's name, Dhiraj Dash. In continuation to this office, earlier letter number such and such dated six. No, Dhiraj Dash. Dhiraj Dash. In continuation to this office, earlier letter number such and such dated 16th of February 2015, number 73 dated 17th of February 2015, and number 77 dated 18th of February 2015. We thank you all for withdrawing your hunger strike from today, that is on 19th of February 15, and consented for joint discussion into the matter. In this regard, we would like to inform you that I am directed to inform you that the desired discussion is scheduled to be held on 23rd of February 2015 at 10:30 a.m. in the office of the agent Kuardi Colliery, in presence of Colliery agent and Sri B.C. Shadhu, Area Survey Officer Shomir Mukherjee, Survey Officer of the colliery with related survey personnel of Kuardi Colliery, and you are therefore requested to please attend this said meeting positively together with your supportive documents. Since then, my lord, no decision has been taken. It is pending. Meanwhile, 2019, my father has expired, and they had really struggled to get one employment in lieu of their land. But my lord, in 2019, he has expired. My lord, since then, it has not been decided. Now, one thing I should draw to your lordship's attention regarding this acquisition, taking of land, there was an issue arose in the ECL itself. One person, there was an issue regarding this taking up of land between the ECL itself. So they accused one employee of the ECL that he has committed some error or wrong, for which he was proceeded with the disciplinary proceeding, my lord, regarding taking of this land, where my predecessor's land was also there. Now, my lord, eventually what happened, the disciplinary proceeding was culminated into punishment, and that has been set aside by the honorable single bench of this honorable court into 2 occasions. And those orders have been annexed. Although it is not the relevant issue in regard with my case, but I thought I should inform your lordship that it had happened earlier. So now, since the disciplinary proceeding has been settled and decided, therefore, my lord, there is no reason why my case of consideration should not be considered. Until today, I am without any employment. Page 54 is the second order, which covers the first order itself.
So was there any appeal from the order?
No, my lord. To the best of my knowledge, there is no appeal. And my lord, this is not directly related to my issue. Only to inform your lordship that regarding that taking of the land,
You're taking care of their defense.
in abundant
You
caution.
are trying to take care of their defense.
Yes, it has been. So, my lord, since his guilt has not been proved, there is no reason. Even if there is something, my lord, I may not be the victim of this non-consideration and lackadaisical nature of the ECL, my lord. That is.
My lord, this is not the last letter, my lord. After that, my lord, on 13th of April 2015, my lord, we have issued a letter to the petitioner, my lord, which is not disclosed over here. I shall disclose it in my report, my lord. There, my lord, we have stated them, my lord, that their employment has been rejected because, my lord, there was a self-imposed norm that he has to be owner of that land, my lord, for minimum 3 years. Actual lordship knows, my lord, these are all self-imposed restriction, my lord. That self-imposed restriction, my lord, was again subsequently changed, my lord, in the year 2017. But this is the case, my lord, of 2005, my lord. So, my lord, we have said to them, my lord, that in that letter, that this is the reason we cannot give you the service, my lord. This, my lord, again, we have given a letter, my lord, on 12th of September 2015, stating the same reason, my lord, that because they have purchased the land, my lord, with 2 deed, my lord. In 1 deed, my lord, they have just 1 year ownership, my lord. So that reason was shown to them, my lord. I shall disclose it in my report, my lord. And I shall also disclose in my report, my lord, our self-imposed norms, my lord. And my lord, when it get changed, my lord, everything I shall disclose, my lord.
My lord,
Your lordship, so allows
may I just
that.
respond to this, my lord? My case of 2005. So I'm governed by the 1992 guidelines for offering employment against acquisition, possession, and use of land. So according to this, my lord, if I may hand over to your lordship, my lord, kindly pardons me for flagging those
No,
my
no,
lordships.
please tell me.
Copy.
Yes. So another document, you should have this.
My
My lord,
lord,
if
you are
your
relying-
lordship kindly
Yeah, copy.
take page 3 clause, 2.1. That I have flagged for your lordship's convenience. The employment against land is offered for sustaining land, oustees, dependents. The norm stipulated below
Page 4.
page 3, my lord, 2.1 clause that I have flagged for your lordship's convenience. So, my lord, it is given irrespective of any embargo, it has to be dependent.
That let him produce.
Yes,
before.
yes, yes,
He
yes.
is relying on a.
And my lord, the 2012, there is a new notification, there is a new clause.
That will not be
The land
applicable.
has been acquired in 2005. I have to
5.
see what was
Yes, yes, yes.
applicable during that time.
Absolutely.
That's why, my lord, I want to
In
flag.
that case, my lord, may I just take back this and attach with the report itself, if your lordship so
Yes.
pleases. Yes.
That I would have given it to you anyway.
Yes, I'm so grateful to your lordship.
Ashwin,
এটা বারোর, এটা
the case of the petitioner is
আপনার
that
কাছে, আমার কাছে একটাই কপি আছে।
is
Your document, sir. It's your document.
that a piece of
আমি
land
সফট কপি পাঠিয়ে দিচ্ছি আপনার। আপনি
belonging to
yes, yes.
the petitioner's father
শুনুন।
was acquired by the Eastern Coalfields Limited within bracket ECL in 2006.
নেটও অ্যাভেলেবল আছে। 1992.
The petitioner's father prayed for employment in the inverted commas and mother italics
So may I just
land
interject?
user category.
May I just interject for once? Kindly pardons me. My lord, will it be the pleasure of your lordship to send it to the authority and decide the issue once for all, irrespective of keeping
Why
it?
is it already been decided?
No, to be decided, that's because there's a representation.
The court.
Very
I've
well, my
given
lord.
you enough patient
Very
hearing.
well, my lord.
After
Very
you
well.
stop submitting, I started.
Yes, I'm sorry, my lord. I just proposed to your lordship.
Kelly land loser category full stop. Representations were made. Several representations were made. And discussions were held with the authorities of ECL. Full stop. However, the petitioner's father was not appointed in the said category. The petitioner's father was asked to meet the appropriate colliery agent and the area survey officer by a communication dated February 19, 2015. Thereafter, no steps have been taken by ECL at all. Full stop. The petitioner's father passed away in 2019. Full stop. Hence, the petitioner has prayed for appointment in the land loser category. Next, Mr. Arifin, learned counsel appearing on behalf of the ECL submits that the petition suffers from deliberate suppression of material facts as the family was, as the petitioner stroke his father was already informed that the qualifying period of owning a land for at least 3 years for seeking a job in land users category, italics, has not been fulfilled by the petitioner's father. Full stop. He prays for leave to bring the necessary documents on record by way of a report on affidavit. Next. Leave as prayed for is granted. Full stop. Next. Now, wait, paragraph. In the circumstances, comma, who will file, Mr. Arifin?
Yes.
Three.
1 minute.
Three or four?
General Manager Satkam area. Three.
কি হলো? By directing? The respondent number 3, stroke the general manager, comma, Satgram area ECL, or any other authority delegated by him, is permitted to file a report by July 21, 2023. Full stop. Exception, comma, if any, by July 28, 2023. Full stop. Let the matter appear for further consideration under the same heading motion bolded on August 7, 2023. Bolded. Server copy. If I see that there is any suppression, Mr. Lahiri, you will know what will happen.
Absolutely, my lord. So that I am not aware of that. Could have been, my lord.
If I find any suppression, that you have annexed only some of the letters and not the remaining letters,
Yes.
and they have been duly served, you know,
Yes, my lord.
consequences.
Absolutely.
Now you cannot say that you only want representation to be considered.
No. Absolutely to your lordship to decide, my lord, because I am not
Now
aware
the
of
court
this.
is in season of the matter. The
Yes,
court will
absolutely.
get into the bottom, get to
Absolutely,
the
my
bottom
lord.
of it.
Because, my lord, I am not aware of these letters. It is not even instructed.
Yes. So that is why it has to be brought before the court.
Yes, absolutely.
Keep your
But I'm for the petitioner.
Yes.
Well, the land of the father of the petitioner, my lord, they had been acquired in the 1978, my lord. Well, the petitioner wrote a letter, 78, my lord. The petitioner made a representation in the year 2016, my lord.
78, it has bin taken
Well,
2000.
gifted, my lord. They not acquired, my lord. They gifted the father of the petitioner. And my prayer is, my lord, the only to consider the representation, my lord. At page 19, 20, and 21 in the official communication, my lord, for getting compensation and assurance of work, my lord.
And then after 2018, what have you done?
Well, nothing has been done, my lord. No, thereafter, no communication has been made, my lord.
And you wake up in 2023. You have a long period of interval in between when you choose to wake up. 78 land has been taken. Then
Still, my lord,
in 2016, you make a representation. Then in 2018, that is directed to be considered. And then now in 2023, you file a writ petition.
my lord.
My lord, I am appearing on behalf of the state, my lord. My lord, instruction not yet been come, my lord.
No. Who is appearing for
Well, the minor irrigation, well, the main
minor
and
irrigation?
answer
That
is
it has to
the
be Ms.
minor
Sinha.
irrigation, my lord. The Sinha.
Response number 3, my lord.
Ashu. It is submitted on behalf of the petitioner that a plot of land under PS Bhagwanpur, district Purbo Benidipur was donated
Donated, my lord.
by the petitioner's father in 1978. The petitioner made a representation on June 24, 2016 for appointment in land user category. Okay, inverted commas, italics. Full stop. Is your father alive or not?
Father alive, my lord.
So why has he not made a representation on your behalf?
The petitioner wanted to my lord, for job assurance, my lord.
The deputy secretary, water resources investigation and development department, government of West Bengal, wrote a letter to the managing director, West Bengal State Minor Irrigation Corporation Limited, within bracket WBSMICL, bracket closed, on July 17, 2017, regarding the compensation
And assurance support.
to be given
Support.
to the petitioner's father and also regarding the assurance of work by the respondent number 3 stroke WBMI CL WBS MICL, full stop. A reminder was also given by the deputy secretary on June 29, 2018 to the MD, WBSMICL, full stop. A second reminder was given on October 10, 2018 by the deputy secretary to the MD, WBSMICL. It is the petitioner's grievance that despite such reminders, no action has been taken by the respondent number 3 corporation, full stop. Next. Where is your affidavit of service?
I have no, my lord.
Affidavit of service, filed in court today, be retained with the records, full stop. Despite service, no one appears on behalf of the respondent number 3. Next. This court directs a notice of the writ petition to be served upon Ms. Sonal Sinha, who usually represents WBS MICL, full stop. A proof of service will be filed on the adjourned date of hearing, full stop. Next, let the matter appear for further consideration under the same heading motion, bolded, on July 24, 2023, bold. Serve a copy. You serve a notice of the writ petition on her and come back.
Lordship, learned advocate appearing in this matter on behalf of the petitioner is on his leg before court number 11, Lordship, praying for only 1 day accommodation, Lordship.
17th.
Well, this is the second occasion.
Why are you bothered, Mr.
No, I am
Good
not.
for you.
I am not. No, not good.
Then you will take all these points that they are not interested to pursue.
No, that's not. Well, not good for me because we not would. Well, at least on 24th,
17th.
17th.
Yes, Monday.
Well,
My lord, 16 is my application, my lord.
16, yes.
My lord, this is
Kindly
my
place.
application. My lord, this is my application, my lord. I am, my lord, the unmarried daughter from the first wife of a deceased, my lord, who died in harness. He was a member of the SSB, my lord, the armed forces, my lord. He was lastly serving as a sub-inspector, my lord. My lord, since his death, my lord, may I place some dates, my lord?
Yes.
My lord, 9th March 2022, my lord, my father died. He had, my lord, initially, my lord, he was married to my mother, my lord, Abriti Das. My lord, I have annexed, my lord, all the documents, my lord, identifying me as the daughter from the first wife of the deceased, my lord. My lord, 9th March 2022, he dies. My lord, after that, my lord, my only claim is for death benefits. My lord, all the death benefits have been disbursed in favor of the second wife
Already
of the deceased.
disbursed.
My lord, they've been disbursed. My lord, it is from time to time, my lord, pension
It has been disbursed already.
it is being disbursed, my lord.
Let me see whether there is a nomination form.
My lord, nomination form I am not aware of. My lord, will see two, my lord, communications from the respondent authorities. They made some, I had made a representation on 24th November, my lord, will find at page 28 to 29. This is my representation seeking dispersal of my share, only my share of the death benefits in my favor. My lord, to that they respond, my lord, at page 37, 5th December 2022. Page 37, my lord, will kindly take.
Divorce হয়ে গেছে তো? হুম?
My lord, this is, my lord, coming from the, my lord, the head office, the pension grievance cell. My lord, will take paragraph 2 at page 37. My lord, has page 37.
Yes.
My lord, the commandant is directed to look into the matter and consider my representation.
Yes.
My lord, will kindly turn over to 38. This is the commandant's, my lord, response. My lord, may I place from paragraph 3 onwards, my lord?
Yes.
My lord, as per available records of late SI Badal Mohanto, who is admittedly my father, my lord, it is found that Srimati Abriti Das was remained wife of the said deceased official, but the name of Srimati Abriti Das was deleted from service book and other documents of official by his previous unit, 12th Battalion, so and so, my lord, due to court order that the marriage tie in between Srimati Abriti Das and Badal Mohanto has been dissolved. As per your office letter dated so and so, Ms. Donna Mohanto is mentioned as daughter of late Badal Mohanto from the divorced first wife, Srimati Abriti Das, but no record, entry, nomination
Nomination of such name.
of such name of Ms. Donna Mohanto found in the service book of the said deceased. Paragraph 5. Therefore, in the sake of natural justice and matter of genuineness of your claim for Ms. Donna Mohanto as daughter of Badal Mohanto from the first divorced wife, it is requested to provide following documents, certificate to this office to enable us to verify your claim. My lord, I have provided all these. We'll kindly turn over to page 39. All these documents, my lord, I have provided, I have annexed. My lord, their only contention, may I take, my lord, to the letter, my lord, which is really creating the problems. My lord, may I kindly take page 60 directly. I have annexed all these documents, my lord, all the documents from page 40 to 59 are the documents proving, my lord, in every, my lord, even my mark sheets, identification cards, everywhere, my lord, I'm recorded as the daughter of late Badal Mohanto. My lord, page 60. Lord, this is the last response, 2nd May 2023. It is intimated that your envelope containing documents took certificates in respect of Donna Mohanto received to this office on 1st March 2023 through postal dark without any application on the subject cited above. In this regard, it is intimated that your essential documents took certificates has sent to our higher headquarters for establishment of genuineness and verification of the ground of your claim. With respect to my lord, dispersal of the death benefits, my lord, paragraph 3, your documents has been verified by higher HQ and directed to ask documents of legal succession certificate. My lord. My lord, that is not a mandatory provision. My lord, they are not disputing my status as the daughter, my lord, unmarried daughter. My lord, I have annexed.
Disputing the genuineness.
My lord,
There is no entry of your name in the service record.
no, my lord. There is no admitted, my lord. There is no, and the nominations are in favor of the respondent number 3, who is the second wife, my lord. My lord, my only contention would be, my lord, they do not say that a succession certificate per se is required. They say from an authority will also suffice. My lord, we kindly consider one page, my lord. My lord, we kindly consider page 44 and 50, my lord. These two documents, my lord, I have provided.
This is your declaration.
Declaration 50, my lord, we'll take 50. It's from the municipality. It's from the municipality, my lord. The municipality also records me as the daughter of late Badal Mohanto. My lord, I have my birth certificate as well. Annex, my lord, may I produce, my lord, may I indicate the birth certificate?
Sorry.
My lord, a succession certificate, my lord, my humble contention would be, my lord, a succession certificate under the Indian Succession Act, my lord, is not a mandatory provision.
How will
So as-
how
lord,
will
I've
they
pro-
verify the genuineness?
My lord, will kindly take my birth certificate. My lord, I've annexed my birth certificate. My lord, will kindly come to page 14.
No, it is not for this court to go into such disputed questions of fact and decide whether it is genuine or not. Yes.
My lord, we are appearing, my lord, on behalf of 456.
The private responsibility.
Nobody is
you are appearing
appearing,
on private
nobody,
responsibility.
yes, nobody is appearing on behalf of Union of India.
Where is your affidavit of service?
কাকে পার্টি করেছে? 1, 2 কেউ নেই। 3 তো হচ্ছে ওরই মা মনে হয়।
I think delivered.
You serve on the office of the Ministry of Law and Affairs over here. Ashun. Affidavit of service filed in court today. Be retained with the records. Full stop. Despite service, no one represents the Union of India. Full stop. However, the private respondents are represented. Full stop. Next. In such view of the matter, let a copy of the writ petition be served on the office of the government leader. Ministry of Law and Affairs addressed at the end. It is the case of the petitioners, next that petitioner, that despite being an heir stroke legal representative of her father, being a daughter through the first marriage, the death benefits of her father, who died in harness on March 9, 2022, being a personnel of Shashastra Seema Bal, are not being disbursed to her in proportionate share. Full stop. The petitioner submits that
This one number 3.
succession certificate is not a mandatory requirement for disbursal of such benefits. Full stop. Next. Let the matter appear for further consideration on July 24, 2023, bolded, under the same heading motion bolded, when a fresh proof of service will be filed on behalf of the petitioner. Full stop. Serve a copy.
What's your placement?
And for the petitioner, my lord. My lord, I am the handicapped son suffering from mental disability. My father was a retired employee of National Institute of Forge and Foundry in Jharkhand. My father was drawing pension. I am suffering from schizophrenia and I have disability certificate. After the death of my natural mother, my lord, my father remarried. So the pension was being paid to my widowed, to the widowed stepmother. When my father was still living, my father had written to the institute that since his son is disabled and the mother is able-bodied, the son should be getting the pension. But the same was rejected by the institute on the ground that a pension can be paid to only one person, my lord. But my lord, according to the CCS pension rules, pension can be shared.
But how does this court have
Yes, ma'am.
territorial jurisdiction?
My lord, I have a 3 judges bench
Yes.
case, my lord, where it says that whether pension jurisdiction can lie where the pensioner resides.
Okay.
He was receiving the, may I hand over the case, my lord?
Thank you.
Last paragraph 32, my lord, last sentence for my lord's convenience. Then I'll go through the judgment. Uh, last 2 sentences, my lord. Paragraph 32. In this case, there was a dispute whether he should file the case from his hometown or Jharkhand, where he was working.
Yes, but he was already getting pension.
This is not in respect of retired employee.
Yes, he was already getting pension.
Well, look, this is also filed by the widow. And here I am also the heir of the retiree. This case has been filed by the widow, my lord. The case, the cited case, it has been filed by the widow. And in this case, I'm the
You
son,
are claiming to be the
handicapped son.
handicapped son.
The time is nearly over, my lord. I can go through the case tomorrow if it's taken up
Yes,
tomorrow.
I'll keep it. I'll make it not today. You consider the judgment by that time. You consider it in detail.
My lord.
Ashun. Ms. Bose, Learned Counsel, opens her submissions. She refers to a decision reported in 2020 within bracket 10 SCC 766. First title to the other one bolded bracketer mode to satisfy the point of maintainability of the writ petition before this court. Full stop. Let the matter appear for further consideration. Let it appear on 10th of July.
10th of July.
Monday. Instead of 10th, not 11th or 12th, any date.
11th and 12th, my lord. My learned friend will not be here.
Not 11th.
11th and 12th.
All right, let it appear tomorrow.
Tomorrow.
এটা তাড়াতাড়ি পাঠিয়ে দেবেন আমি সই করে দেব। Let it appear on July 4, 2020.
My lord. নাম দিয়ে দিয়েছো?
5.
July 5.
না 5 কি করে? কালকে তো Wednesday. No, tomorrow I won't be taking up new motions. So it can appear on the 10th because tomorrow is Wednesday. I won't be taking up new motions.
10th আছে?
Otherwise 17th.
17th.
Let it on 17th.
17th.
7th. Under the same heading motion. Yes.
Number 20. I went
Yes, Mr. Banerjee.
Yes, Manoj. So essentially two things. Your Lordship recorded there. One is there is a letter of appointment. Now, the regulations that govern applicable legally, I had made one incorrect submission on the first day where I said that the rules are also under the regulation. That was not correct. Rules are also framed under the statute. There are different provisions in the act which allow them to frame the regulation, and the act also allow them to frame the rules. The rules are under the act. The issue here is when there is a set of regulations that govern the employer and employment relation, the employer-employee relationship, and then there is an inquiry procedure that is prescribed there, which is in consonance with the requirements of principles of natural justice, then by a rule, can you disregard that protection that is given to me? From whatever I've read, Article 311(2) does not apply to me. So protection under 311 is not applicable to me. That was a very late preparation that I had. I was not prepared to do the matter. So then I went back and read it up because I was just told that the matter was going to, so I quickly made a note, but I gone back and read up. 311 is not available to me. But it's also the law, and I'll cite a judgment, that this policy or even a rule or a regulation that does away with compliance of principles of natural justice and allows an employer to adopt a hire and fire policy, that is hit by Article 14. Even if that rule is mentioned or stated to be being applicable to me in my letter of appointment that is there. Now, this particular rule is under challenge before several other writ petitions that are pending before this Honorable Court. And I've annexed, I really should not have, but there are a lot of orders that have been annexed to the writ petition, which say that the proceedings will continue, but you will not pass a final order without taking the leave of the court. The three things I'll just show to your Lordship. Kindly have a look at page 152. This is my initial letter of appointment. This is dated 30th April 2016. This confirmation is at page 157. I must indicate this to your Lordship. This is of 10th of May 2018.
Yes.
The last paragraph.
Yes, I've seen that last paragraph.
Yes. So the 1960 regulations also apply.
Yes,
and
so both apply.
Both have been made applicable to me. So this is one hurdle that I'll have to cross, that if it's there and I have agreed to such a term, can I now come back and tell a court that this is ultra vires Article 40 and this is now what is the protection that is given to me under the regulation? That is at page 81, Milan. Now the issue is here that I am stated to have not worked to the benefit or the business of the corporation. In other words, what I bring in is not adequate for what is as a payout to me. Now, keeping this in mind, Milord, kindly have a look at page 81. The part of the regulation is regulation 39. Without prejudice to the provisions of other regulations, any or one of them, the following penalties for good and sufficient reasons as hereinafter provided be imposed by the disciplinary authority specified in Schedule 1 on an employee who commits a breach of regulations of the corporation or who displays negligence, inefficiency, this is important, or indolence, or who knowingly does anything detrimental to the interests of the corporation or conflicting with the instructions, or who commits a breach of discipline or is guilty of any other act prejudicial to good conduct. Inefficiency is one of them. Kindly have a look at G, 39(1)G, dismissal. 2, no order imposing on an employee any of the penalties referred to in B to G of subsection of subregulation 1 supra shall be passed by the disciplinary authority specified in Schedule 1 without the charges being communicated to him in writing and without his having been a reasonable opportunity of defending himself against such charge or charges and of showing cause against the action proposed to be taken against him. The disciplinary authority empowered to impose penalties under A, B, C to B to G may itself inquire into such charges and are not admitted, or if it considers necessary to do so, appoint a board of inquiry and inquiry officer for the purpose. So there is a full-fledged disciplinary proceeding by a particular authority that is mentioned. Now kindly have a look at the offending rule. It starts at 120, Milan. (129) is a relevant rule. 6. Opportunity to conform to the expense limit, where the annual remuneration of any development officer in the preceding year or years is in excess of the expense limit, his services shall not be terminated merely on that ground that if his case is capable of being dealt with by awarding disincentives, subject to provision of Rule 8 from the relevant appraisal date as provided in the table of disincentives, so as to afford him an opportunity to conform to the expense limit. Now, I'm sorry, just give me a minute.
You referred to page 133.
133 is the, yes,
Regulation of services.
yes,
certain cases,
Regulation
clause
7. I'm sorry, Regulation 7, 133. Where a development officer has failed to conform to the expense limit and when an opportunity to conform to such limit could be given under provision of Rule 6, the zonal manager may terminate his services after giving him 3 months notice or salary in lieu thereof, provided the development officer shall be given an opportunity to show cause against such proposed termination of his service. So in effect, kindly see, it's show cause against the proposed termination of his service, and it can be terminated by his services by giving him 3 months notice or salary in lieu thereof. So the protection that is given to me by framing charges, and the entire thing that is contemplated by the Regulation 39, that is being done away here. This is a complete hire and fire policy where instead of 3 months notice, you can throw me out or you can take away the salary. If you don't want to give me notice, then you give me the salary for 3 months and I'm out. This does not have any resemblance to what the regulation provides to me. This kind of hire and fire policy, this rule is under challenge here. And now kindly have a look at one particular decision. This 2013 8 Supreme Court cases 3, 4, 5. Copy carry করছো না? তোমাকে এটা আমি নিজে পাঠিয়েছি। Well, this is also in the context of Bama lorry, which was held to be a state under 12. Even Article 311 was not found to be applicable. 2 paragraphs, Your Lordship will just allow me to place, This is paragraph 29 and 30. But I'm sorry, my lord, I have only one copy. If Your Lordship could just
give the reference.
2013 on judgment of Workmen versus Hindustan Steel Limited held that where a regulation enables an employer to terminate the service of an employee in an entirely arbitrary manner and in a manner that confers vicious discrimination, the same must be struck down as being violative of Article 14 of the Constitution. Therefore, even the standing orders must be non-arbitrary and must not confer uncanalized and drastic powers upon the employer, which enable him to dispense with an inquiry and further enables him to dismiss an employee without assigning any reason for the same by merely stating that doing so would not be expedient and that it would be against the interest of the industry to allow continuation of employment with respect to the employee. Now, these two lines are important because the only reason I'll show the show call is actually the business efficacy of the transaction. The pay in vis-a-vis the payout. So because I'm not bringing in adequate business, the charge is of nothing else except that what I'm bringing in is not adequate enough in comparison to what they give to me. For that, if a rule allows such uncanalized power on the employer to dispense with an inquiry and without assigning any reason whatsoever to dismiss or terminate an employment, that has been found to be violative of Article 14. This is primarily because such a procedure is violative of the basic just paragraph 29 violative of basic requirements of natural justice. Such power would tantamount to a blatant adoption of the hire and fire rule. You would have found the, you should kindly have a look at. Guruve, 29. No? May I place it again for your lordship's consideration?
You just give me the paragraph numbers.
29, my lord.
Yes, yes,
Yes.
that's all.
30 disregards this because this is on basis of element of public interest. It's hackneyed, it's settled, it's same. One thing I wanted to indicate in paragraph 30, my lord, it goes into section 23 of the Contract Act. What is an unconscionable bargain? Not that, but just the last 4 lines of paragraph 30 before paragraph 31 starts.
Yes.
The state itself or a state instrumentality cannot impose unconstitutional conditions, kindly mark this for now, in statutory rules or regulations vis-a-vis its employees in order to terminate the services of its permanent employees in accordance with such terms and conditions. So even if this is there in my letter of appointment, does not absolve them of their obligation to conform to the requirements of Article 14.
1 second.
Yes, ma'am. Present show cause stuff. No.
Yes, tell me.
Your Lordship has seen that clause, my lord, at page 134. Now kindly have a look at this alleged purported inquiry that they undertake. Kindly have a look at the impugned show cause notice at page 173 and tests whether what is given under this rule and this show cause is really a cause to that I can show. (173), before the name of the petitioner is mentioned, at the top, Rule 7 of the Life Insurance Corporation of India, revision of so and so, disregards the first bracket, my lord, letter to be issued to those development officers who attract termination of service. Then immediately after, there's a horizontal line that runs across the page, my lord. Your Lordship will find just above that, your performance for the appraisal year ended 30th April 2023. Disregards A and B. C, just one line from there. It is observed that your annual remuneration for the appraisal year ended 30th April 23 exceeds 50% of the eligible premium of that year. It is also observed that your cost ratio for the immediately preceding appraisal year ended on, and then there are some figures. Now kindly have a look at the scope of the show cause notice. After that C ends, you are hereby given an opportunity to confirm through a representation in writing the discrepancies, if any, in the figures relating to your performance as mentioned in clause A.
Soft copy. Yes.
So the only window of this purported representation on natural justice is to confirm through a representation in writing the discrepancies, if any, in the figures relating to your performance. So if the figures are right, then the employer has a right by dint of this rule to fire me by giving me 3 months notice. Well, this is a complete hire and fire policy because it allows the employer to dismiss a permanent employee on the ground of inefficiency without any proper inquiry at all. So I am not even given an opportunity to show as to why I could not get or achieve certain figures. That is in requirement of natural justice. Why I could not achieve the expense ratio or the base ratio, if that could have been a part of the show cause, and I could have tabled that for consideration, then I could have still understood. But all I have to reply or can reply to is to confirm the numbers without getting an opportunity to show cause as to why I could not get those numbers that are alleged against me. So the performance or the basis is not under scrutiny. It's not why, it's what. Why have I not done it is not a part of the show cause process. What have I done is a part of the show cause process. This is an uncanalized, arbitrary power that the employer has retained unto himself by dint of this rule. Because considers this. There is a provision for appeal under this. My scope of inquiry is only why the figures are correct or wrong.
You have given a fairly detailed reply. What happened after you gave the reply?
Well, I gave the reply the day I filed the writ petition. And because they were otherwise going to terminate me. I had 15 days to do it. So I gave that reply and I filed the written. I came before this court. And I've challenged the virus of the rule itself. Now, there can't be a waiver of a fundamental right. It's also not open to a state to take these point of technicalities. Lordship is aware of the 79 Supreme Court judgment. The state can't take these points of technicality of waiver, limitation. That's not available to a state. Here, they will have to come forward and explain how a rule is there which looks at what and not how. And that is in complete departure of what the service jurisprudence that your lordships have developed over the years. And to buttress that, I've relied on this 2013 judgment. It is really an untrammeled, uncanalized power that they've retained unto themselves, even if it be in the rules, which is why I placed that paragraph 30, last few paragraphs. So simplicity reference to the rules in my employment letter does not give it a far higher exalted status of it being permissible. Now, this is one part of my argument, my lord. I'm prima facie, my endeavor has been to show that it is in violation of Article 14. Secondly, this virus is under challenge. I'm on the aspect of committee of courts now. Although these are interim orders, because there are several challenges that are there to this rule itself. And the court has passed orders. I am not aware of what has happened in the Supreme Court judge matter, my lord. I have not seen it. I'm sure Mr. Mujumdar will be better equipped to apprise your lordship on that. But when there are several writ petitions challenging this particular rule is pending, and where the courts have consistently passed an interim order, the respondents will have to show some change in circumstances, some difference in the situation to invite your lordship to take a contrary view. Those orders are there, my lord. I just referred to them. The gist of it is that it will continue. The final order will not be given effect to without taking leave of this court. And this is simpliciter on an issue of law, my lord. If the respondents agree and your lordship's business permit, without any affidavits, any factual investigation, we can just argue on the issue of law and finish it. There are two other judgments which are on similar lines, slightly later one.
Let me just hear Mr.
Yes, yes, ma'am. These are my respectful submissions for now.
But first of all, Lord, this is only a show cause to carry it further forward and to act in accordance with the rules. But my learned friends, stronghold is the judgment reported at 2013-8 SCC.
Yes.
Please have a look at paragraph 4 of the judgment. Somewhere in the middle portion of the paragraph, a sentence beginning with the words, his services were terminated.
Yes.
His services were terminated with the order dated 27th of February 1981 in view of clause 11A of the letter of appointment, a contract, which provided that the company would have a right which would be exercised at its sole discretion to terminate the services of such employees by giving them 3 calendar months notice in writing without assigning any reason for such decision. So what fell for consideration before the Honorable Supreme Court in the reported judgment was a contractual term which provided for a compensation against termination without any reason. Not here is a statutory rule. Not he is a development officer whose service conditions are quite different from other staff of LIC. And what this has been the position since 1989. Similar rules were there in 1989, 2009, then 2016. Only the figures have changed. Now, your lordships have laid down the law that whenever a virus of a statute or regulation is under challenge, courts normally do not pass an interim order. It's really in the nature of a precautionary measure that their lordships in the Honorable Supreme Court had observed these words. Judgment. It's reported at 2014-14 SCC 496. So long as the rules are in existence, not an employer cannot be said to be flawed by acting in terms of the rules unless those are set aside. 2014-14 SCC 496. Paragraph 13, if I may please. We have considered the respective arguments and submissions and carefully perused the record. Since the matter is pending adjudication before the High Court, we do not want to express any opinion on the merits and demerits of the writ petitioner's challenge to the constitutional validity of the 2003 Act and the 2004 rules as amended in 2005, but have no hesitation in holding that the High Court was not at all justified in passing the impugned orders, ignoring the well-settled proposition of law that in matters involving challenge to the constitutionality of any legislation enacted by the legislature and the rules framed thereunder, the court should be extremely loath to pass an interim order. At the time of final adjudication, the court can strike down the statute if it is found to be ultra vires the Constitution. Likewise, the rules can be quashed if the same are found to be unconstitutional or ultra vires the provisions of the Act. However, the operation of the statutory provisions cannot be stultified by granting an interim order except when the court is fully convinced that the particular enactment or the rules are ex facie unconstitutional and the factors like balance of convenience, irreparable injury, and public interest are in favor of passing an interim order. Not coming to the exceptions, balance of convenience. Not in the event it is found that the rules were not constitutional, what remedy does he have? A compensation in terms of money. He will get back his service and he can be compensated in terms of money. Irreparable injury is also taken care of by not the well-proposed principles in a lordship have categorically laid down the law that even in cases of termination, transfer, etc., or suspension, courts normally do not pass interim order because this is not an irretrievable injury or some sort of a damage which cannot be compensated in terms of money. Third, public interest. Now, this is not a question of public interest having been involved. I'm not coming to the case in hand. Development officers in LIC always enjoy a different status vis-a-vis other employees or staff of the corporation. They have different service conditions in the nature of emoluments, bonus, grants, etc. 2017 onwards, he had been thrice granted extension for the purpose of confirmation till he got to be confirmed in 2018. Since 2019, his performance was under scanner when on each occasion he was issued this notice for the purpose of rectifying himself. And this is inbuilt provision in the statute forming a part of natural justice. Whether this is sufficient or not, your lordship will decide at the final hearing. When he says that I had been issued a show cause, that itself is indicative of compliance of some principles of natural justice, the length and extent of which is to be tested when your lordship will consider the virus of the rule. So not all these interim orders, I take note. The first interim order was passed when the learned, way back in 2017 or 16, when the learned counsel representing LIC did not have the instruction or the records with him. So the court was pleased to pass an interim order. The same reasoning was extended by the Honorable Division Bench when he said, since the learned counsel does not have instruction, so there be an interim order. And in the meantime, the Supreme Court, the matter had been pending before the Supreme Court.
What happened?
The Supreme Court, please have a look at the Supreme Court order. After Supreme Court, the Allahabad High Court had held the rules to be intra vires. The matter went up in appeal before the Honorable Supreme Court. The Supreme Court remanded the matter to the Allahabad High Court, holding that all the points had not been addressed by the Allahabad High Court. But at the same time, the SLP file was dismissed as withdrawn.
So now it is pending adjudication before Allahabad High Court.
And different other high courts.
Division bench.
No, not wherever some courts have not the system of taking up admission even at the division bench level. It's like that. Before the Honorable Supreme Court's judgment, the Karnataka High Court and the Allahabad High Court had declared these rules to be intra vires. In fact, 3 judgments: Madras, Allahabad, Karnataka. Please have a
Mr.
look.
Majumdar, he has already filed a reply. So
Yes,
to the show cause, you have to take a decision.
my lord.
But till such time the court is in season of the matter, kindly do not pass any final order without the leave of the court.
But all these judgments and not the points had not been addressed, not been advanced at the time of passing
Yes,
of the
but
interim orders.
please do not pass any final order.
Grateful.
Because to the mind of this court also there is a distinction as far as the facts of this case is concerned with the facts of 2013 that Mr. Banerjee has cited, because here there's a provision for show cause and reply. Over there it was not. But even then, since he has come and he has come and filed a writ petition, please do not take the leave of this court before you file, and you take a decision. In the meantime, you take a decision.
But I have cited that paragraph 13, which is the till such time the rules are in existence. These are the only three exceptions.
Yes, but it might the court has to decide whether it is irreparable injury.
In that matter,
In the event,
there are cited.
suppose
There are the previous interim orders you must have considered
But the
have
previous
been
interim
passed
orders-
on the issue of balance of convenience.
not the previous interim orders, I tell your lordship the history of passing the interim order. There, I have got the original orders. The first one, records not produced. The second order, the learned council did not have the instruction. And all these interim orders, your
But
lordship.
it is passed on the
And
issue of
third ground
balance
was
of
pendency
convenience.
of the SLP before the Supreme Court. Now the SLP has been disposed of, or rather dismissed as withdrawn, since the Allahabad High Court was again requested to adjudicate certain other issues which were raised but not adjudicated by the court.
Yes, Mr. Banerjee, what are you saying?
No, the decision that Mr. Mojumdar cited, there your lordship will find in paragraph 10 onwards, no one had appeared before the court.
No, that is all right. I
On
am
that
not,
ground-
I am not basing my
No, very well. So,
ordered now at the moment on
Yes,
that.
very-
Ashwin. By an order dated June 12, 2023, this court recorded that the letter of confirmation dated May 10, 2018, issued in favor of the petition, clearly indicated that the Life Insurance Corporation of India, within bracket staff, bracket closed, regulations 1960, and the provisions of the Life Insurance Corporation of India, development officers, within bracket, revision of certain terms and conditions of service, bracket closed, rules, 2016, will govern the service conditions of the petitioner, full stop. Admittedly, the petitioner is a development officer of LICL, full stop. Next. Mr. Banerjee, learned counsel, appearing on behalf of the petitioner, submits that the virus of Rule 7 of the rules, 2009 rules has been challenged in the present writ petition. Full stop. He submits that without giving an opportunity of hearing and complying with the other principles of natural justice, an employer cannot terminate the services of a permanent employee, full stop. He refers to a decision reported in 2013 within bracket 8 SCC 345. Cost title ta kore dev. 2013 8 SCC 345. Cost title ta kore deben bold bracket number. In support of his contention that even though the letter of appointment may contain a clause in respect of termination of the employee's service, the employer cannot do so arbitrarily and without assigning any reason, only on the ground that the interests of the industry will be prejudiced in order. Now, in the event the employee is allowed to continue with the employment. He submits that the 2009 rules are in violation of Article 14 of the Constitution of India and therefore should be set aside and quashed. Full stop. Next, furthermore, he submits that there are several writ petitions pending adjudication before this court. Full stop. The interest of the petitioners have been protected by way of interim orders in those writ petitions. Full stop. Next, Mr. Mujumdar, learned counsel appearing on behalf of the respondent corporation submits that the service conditions of the development officers are different from the other staff of LICI. Full stop. It is not so that it is not so that the principles of natural justice have not been complied with. Full stop. The fact that the petitioner has been issued a show cause notice and a reply has been invited from the petitioner in itself goes to show that the employer was seeking to comply with the principles of natural justice. Next, he relies on a decision reported in 2014 within bracket 14 SCC 496. Cost title bracket in support of his contention that in the event the virus of an act or statutory rules are challenged, no interim protection should be given to the petitioner unless ex facie the factors, unless ex facie the rules are unconstitutional and the factors like balance of convenience, irreparable injury, and factors like balance of convenience, irreparable injury, and public interest are in favor of passing an interim order. Full stop. Next, he further submits, that the previous interim orders have been passed by this court since neither the documents in favor of LICI were produced before the courts nor were necessary instructions brought on record by on behalf of the LICI. Full stop. Next, considering the rival submissions of the parties and the materials placed on record, this court is of the view that the present writ petition has to be adjudicated by way of filing of affidavits. Full stop. However, this court is also of the view that the petitioner has been prima facie, italics, able to make out a case of balance of convenience in his favor, full stop. Therefore, no final order that is passed after consideration of the reply given by the petitioner to the show cause notice shall be passed without the leave of this court, full stop. Next. Affidavit in opposition to be filed by
3 weeks.
by 3 weeks from date, full stop. Reply, if any, by 2 weeks thereafter, full stop. Parties will be at liberty to mention the matter for hearing, bolded, upon expiry of the period stipulated for filing of affidavits.
No, the affidavit of service became.
My affidavit of service filed in court became.
Very good.
Mr. Mojumdar, even in this matter, the LICI was not appearing. And I had to ask them to give notice again. Then someone said that you usually appear. Yes.
On one day I appeared, it was taken up and it was decided that it would be taken up at 4 o'clock. Then at 4 o'clock.
No, it's not this, before that.
Thrice before that we had tried to
Thrice
serve.
before that. So even in this matter, this court would have passed an order without hearing the LICI. They have shown their affidavit of service. LICI was not represented.
And I'm grateful for a symbiotic relationship in this regard.
Great.
Lordship, item number 42.
Your Lordship, I am for the petitioner.
I am for the respondent, Your Lordship, in this matter.
Your Lordship, on the last occasion, Your Lordship had directed the respondent authorities to file additional affidavit of report. And Your Lordship, you had also directed the respondent authorities to send the petitioner number 1 for screening and inquiry of dependency.
Lordship, to that effect, screening has been completed, Your Lordship. I'm just praying a week's time to file my affidavit, Your Lordship. Just a week's time, Your Lordship.
Ms. Dasgupta, learned counsel appearing on behalf of the petition of Eastern Coalfields, on behalf of Eastern Coalfields Limited within bracket ECL, submits that the screening of the petitioner number 1 screening.
Petitioner number 1 screening. We have inquired all the petitioners, Your Lordship. I'll come up with the report, Your Lordship.
Petitioner number 1 screening. No, petitioner number 2 screening.
No, Your Lordship.
Petitioner number 1 is the daughter of the deceased employee, and petitioner number 2
1
is the son-in-law.
Has been already concluded as directed by the order dated May 2, 2023. Full stop. She prays for time to file her report regarding the same. Full stop. To file her additional report on affidavit regarding the same. Full stop. Next. Let such report be filed by July 14, 2023 upon an advance copy being served on the learned advocate appearing on behalf of the petitioner. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on July 17, 2023. Bold. Serve.
Grateful.
Much obliged, Your Lordship.
I am for the respondent notes.
My lord, in this matter, my lord, on the earlier occasions, your lordship was pleased to give the directions to the respondent authorities to produce the original register, my lord.
Bring all three bundle.
Now you show me which one are you relying on? Which docket number are you relying on? You are saying that
Three letters,
wait, let him place his case. You are saying that immediately upon his death, an application was made by the grandmother.
Lordship.
Now you tell me which representation you are relying on.
My lord, page at 37, my lord,
37,
37, 36, 37, my lord. And my lord, 35 is the death intimation, my lord.
37. Let me first see. $37.
37, my lord. My lord, 36 is another letter, my lord. And my lord, 35 is the death intimation, my lord, which has been received by the respondent authorities on 4th January 2010, my lord.
Yes, there is no dispute with 35. The dispute is
No,
with
dispute is,
regard
yes,
to
35 is not-
36 and 37.
35 are not received. This is it, Lord.
But
I bring.
আচ্ছা,
Not bring.
ওটা আমাকে দিন registered.
35 is not also. 35 is also not received. 4th January, Lordship, not received. Right hand side.
Now this first, let me see page 36, 4392.
35, Lordship, 35 first, Lordship, 35 is also not 4th January, Lordship. Top 4th one, 10.
Yes.
Top. Not received. That number is not gone.
Here there is no docket number, so I cannot verify 35.
Yeah,
I cannot verify 35.
That
but let
letter
me
is also not received because in the receipt.
Please stop about 35. Come to 36, 4392. Where is the docket number?
Date. 36 dates.
36, there is no date. That is why I am stuck. That's why I asked you to bring the original register.
Also, Lordship, 36 not received. Nothing on 3-year letter not received. This is also 35, 36 not received. 37 no letter received. I bring all the 3 registers.
My lord, this is the copies, my lord, which bears the original seal of the authorities, my lord, and even the signature also, my lord.
552.
I Lordship, page
2010, 10 552.
January.
যত রাজ্যের এখন ডকুমেন্ট প্রডিউস করে রয়েছে 12 দাঁড়ান এটা ডিসেম্বর 17 না মোটো তারপরে এটা দেখি
docket number 4392 never gone.
Four 392. Wait,
Never gone, never gone,
never come.
never. This is my clear statement in the report. Never gone. This is 13 years, 30.
There is, what have you mentioned against 4392?
Never gone, Lordship.
NS, what do you mean by NS? Look against 4392. What have you mentioned? What is this entry?
Sanction for pecuniary store not related to lordship.
What are you saying?
Electric lordship, something else, electric lordship.
You have to tell me, it is your record.
Not electric side, electric some store work, dispatch and receive register lordship. We have not received any representation in 3 years. Yes, 20 I received and the case was rejected.
Yes.
Malad, all these are the copies of the
Yes,
letter.
I know what you have done and you have how you have put in the
Malad, bearing
in
the
the
original
documents.
original seal, Malad, and the
After
valence.
10 years, notes are fresh.
Because of you, I asked these registers to be brought. This has not been handed over by the petitioner's grandmother within the time, as you were saying.
After 10 years,
Because
should be not
552 is an entry prior to the death of the petitioner's father. And 4392 is an entry. 4392 is an entry after 2 years. So it does not tally with your submission at all that it is done during just immediately after the death of the petitioner.
But Malad, the seal clearly indicates that this applications has been received by the office of the general manager, Malad.
That was general manager register.
This registers.
General
This is why
manager.
I wanted to see, because now this kind of petitioner will be awarded costs.
But Malad, since the respondent authorities received the
After 10 years, notes are new.
as and when the petitioner was
Both of you can't speak together. Mr. Kumar, this is in this matter, I am with you. Why are you agitated? I have brought the registers for a particular purpose.
Malad, upon the demise of the father of the petitioner, the respondent authorities received the death intimation, and Malad, as and when the petitioner was at about 12 years, Malad. Malad, law is that upon receiving the death of intimations of the employee, the respondent authority, the authorities is to keep the name of the petitioners on roster, Malad.
How? If you do not pray for compassionate appointment, now you cannot circumvent the issue.
Then, Malad, upon attaining the age of majority, it is the duty of the authority to offer this the job, Malad, to the.
All that is all right. The question is whether you have made an application for compassionate appointment. And if so, when you have made. So now if you have not made and you have fabricated documents to show that you have made an application earlier, now you should be prepared to pay some costs so that this kind of writ petitions are not filed. There has to be some kind of a deterrent. And this is the reason why this writ court has gone into this exercise of personally scrutinizing the documents. This last week also I have done in the appeal court. And because of that, the entire issue came to the fore. Because painstakingly, this court went through each and every entry. So now I have perused the documents myself. Now the petitioner has to be prepared to pay some costs so that these kind of litigations are not brought before this court.
Malad, kindly give me some time to take instruction in this regard, whether this documents was placed.
Please take instructions how you will pay costs.
But Malad,
because this court knows how to recover costs. On last Friday, this court has delivered a judgment sitting in division bench how to recover the costs in these kind of matters.
And Malad, kindly come to page, Malad.
No page number, nothing.
Malad, that application also made within a reasonable period of reasonable time, Malad.
Ashun. By an order dated June 6, 2020, this court directed Mr. Kumar, learned counsel appearing on behalf of Eastern Coalfields Limited, within bracket ECL, bracket closed, to provide original registers relating to docket number 552 and docket number 4392 in view of the submissions made on behalf of the petitioner that the applications for compassionate appointment of the petitioner was made by his grandmother immediately upon the death of the petitioner's father. Full stop. Therefore, it was submitted that there was no reason for rejecting the application for compassionate appointment on the purported ground that the same was made after 9 years, 6 months from the date of death of the petitioner's father in 2019. Full stop. Next. Pursuant to the directions passed by this court, the original registers have been produced before this court bearing such docket numbers. As against docket number 552, it appears that the subject matter relates to Mondarbuni colliery regarding some confidential matter. Full stop. As against, now the said docket number was entered on June 29, 2009, prior to the date of death of the petitioner's father. Full stop. The petitioner's father died on December 17, 2009. Full stop. Next. As against docket number 4392, it appears that the same has been entered on May 21, 2012 regarding some issues relating to electrical motor. Full stop. Next. The said docket number was not entered in 2010. Full stop. This court has no reason to disbelieve the entries made in the original register, which has been produced, registers which have been produced before this court today. Full stop. Next. Mr. Paul, learned counsel appearing on behalf of the petitioner, prays for leave to take necessary instructions in the matter. Full stop. Next. Let the matter come up for further consideration under the same heading motion, bolded, on July 17, 2023. Bold. Full stop. Server copy. If you want, you satisfy yourself. Look at the entries made against 552 and 4392. Mr. Kumar will submit you.
I will.
Appearing for the petitioner, your lordship. Your
I am
lordship,
for the respondent, lordship.
Yes.
your lordship, I am being led by Mr. Sumirar Mandal, who is engaged in court number 42. Your lordship.
Yes.
Kindly
You want to
accommodate.
submit? Submit if you want.
Your lordship, kindly accommodate for today. I have instructions for
17th.
Lordship.
your lordship.
I bring one judgment of Justice Dipankar Datta. His lordship was here. Very good judgment, lordship. With regard to this, when applied, application is not matter. Matter is related to when approach the court. After considering a 9th to 10th judgment, his lordship passed out. Very good judgment. In that matter, I am learned from short time in the matter.
What? Which matter?
In the time, my learned for short time.
Yes.
In that matter. I bring the very good judgment of Justice Dipankar.
All right. Thank you.
About 9 judgment, his lordship consider when his lordship was here.
Your lordship,
And
if,
then this is the case.
your lordship, if one copy of the judgment is given to us.
You give him the reference. He can be
This
prepared.
is
and
a reported judgment, but I
yes,
give
you
the
give
copy.
it. You don't have to give him the copy. You give him the reference.
I
He will
handed over.
consider and
I handed over.
hand it over. So you are being very helpful today.
And
Yes.
these are reported in all the journal, but I take out from the net. I
Mr.
handed over.
Ghosh is not so lucky when he appears on the other side. Today you are giving a copy to your learned friend.
Thank you. Grateful, lordship.
ওনাকে ফেরত দিয়ে দিন, ওনার অরিজিনাল রেজিস্টার ওনাকে ফেরত দিয়ে দিন। কি?
I will return, lordship, this.
Yes, yes.
Grateful.
Item 55 I am for the petitioner. The 6th of June 2023. There is a direction passed by your lordship. Prior 6th June. Prior to that, 1st of May, I was directed to serve copy upon the added respondent number 8 and to file affidavit of service. That has been served properly.
So who is representing the district judge?
Mr. Shantanu Moitro. Oh,
Shantanu.
Shantanu Kumar Moitro.
Yes.
They have supplied me their report, my lord, which they are supposed to file before lordship in original.
Have you gone through the report?
Yes.
What do they say in the report?
They are disclosing that the respondent number 8 is working, he is in government job, though not permanent in nature, and he applied here as exempted category candidate. My case was that a person who is holding, my lord, exempted category
He cannot use it twice.
Yes. Once you are employed anywhere, you lost the force of.
So what do they say? That he is already working in the.
He's already working. His application shows that. The application.
That is what the district judge is saying.
Yes, yes. May I share it?
Oh.
May I read it out?
Yes.
In the application form of the respondent number 8, in view of the aforesaid employment notification, it is mentioned that he is a government servant in temporary position. But it is not clear from the same that whether he has availed the benefit of exempted category earlier or not. That is what
Here the application form shows.
An unemployed person can use the benefit of employment exchange card.
Now the district judge is saying that it is not possible, even if the form says EC, it is not possible for the person to, the district judge to say that whether he has availed of.
It's not required, my lord. It's not required.
1 second. You have served upon the added respondent.
Yes. Twice. Private respondent, I have served twice, and twice while he received it. I have annexed the track reports also.
He is still working with the district judge person, Barthaman?
No.
No.
He didn't join here. He said
didn't
since this writ petition is pending, I will not join. Let me work somewhere else where I have been working.
And where is the state today? Where is Mr. Moore?
But if your lordship keep it tomorrow, my lord, I can intimate Mr. Moitro to be present before lordship with the original copy of report. As you wish.
I'll keep it on the 11th.
Wait. Good.
Ashu. No one represents the district judge, stroke, the state today, full stop. No report has been filed. No report is filed on behalf of the learned district judge. Paschim Bardhaman, even though this court is informed that a copy of the report on affidavit, that an advance copy of the report on affidavit has been handed over to the learned counsel appearing on behalf of the petition. Full stop. Next. Let the matter appear for further consideration on July 11, 2023, when 23 per comma, when it is expected that the learned district judge will be represented through the state advocates. Full stop. So,
Good.
you're not happy, Mr. Banerjee? What happened?
No, my lord. I have nothing to do in this matter, my lord. I have, my lord, really no, my lord, Odis. No role
You
to
seem
play
very unhappy. What happened?
for some other reason.
All right.
For some other reason. Grateful.
Great.
Great.
Yes.
My lord, last occasion, your lordship directed my learned friend, my lord, appearing to take instruction as regards to the, my lord, admission certificate, which has been issued by the SSC, which is, my lord, mismatching, my lord.
Yes.
My lord, my learned
Which
friend has,
document is it?
my learned friend has, my lord, handed over a copy of the, my lord, such instruction.
You have seen these report of the question department. You have perused that.
Yes, my lord, I have on that very day, my lord, I have handed over copy.
Lordship will kindly see that this report has been issued.
So this is your document.
My lord, on the basis of that, my lord, which was sent by the SSC, my lord,
You have to explain the process to me, because only on this document the signature is mismatching. So now you have to explain the process. How are this admission certificate? How is because they are saying that it is for the authorities, because how the from whose signature the authorities obtained in the admission card, they cannot say. But in all their documents, the signatures are matching. Now you have to tell me what is the process of issuing this admission certificate.
my lord, there it was held by the
So when
comment was
you
made.
give the admission certificate, do the candidates sign and accept them? How is it done?
My lord,
May
I can say that only.
No, not you. He has to explain.
My lord, only one comment was made by the commentary that
So far, it is proved. Mr. Bhattacharya has been saying admission certificate is issued by you.
Yeah.
Now, this document that you produce also shows that the admission certificate has been issued by you. Now, what is the process of issuing the admission certificate? How does the signature of the candidate appear on the admission certificate, which is a document issued by you? You have to just explain that to me.
my lord, there, my lord, it was done on online, and the thing that was uploaded, and from there, that the authority
So
called it.
where is the issue? How is that signature appearing on the admission certificate? This process you have to explain.
The
to me.
signature was given in the form that was uploaded by the SSC. And
Now that form, that signature is not mismatching. The only thing that is mismatching is the signature in the admission certificate, which is your document. So how has the petitioner tampered with it? I have to understand that.
my lord, the instruction that was I received, I have handed it over to your lordship.
That
now.
I have also seen. Now you have to explain this to me. Otherwise, this matter can never be resolved. How many days will I keep it pending? All the signatures are matching except for one signature on a document that is your document.
My lord, that explanation I'm yet to receive from the department. That's why, my lord.
How long it will take, I don't know.
Yes, Mr. Bhattacharya, what do you want
Since
to say?
2022, my lord, on this issue, my lord, this petition is pending, my lord. My lord, so far my instruction is this, my lord. So far the, my lord, admission certificate. My lord, at the time of filling of a form, my lord, My lord, a candidate has to sign in a, my lord, very narrow space, my lord. My lord, if your lordship kindly consider my writ petition, your lordship will find. Kindly comes to
I
my
have
lord
seen that.
page 20.
20. I'm looking at 20.
Page 20, my lord.
20.
20.
12.
No, no, my lord. 20.
20, yes.
20. My lord, this is the, my lord, form.
Yes.
This is the form where I have signed, my lord. The photograph is there, my lord. In the,
Yes, after the photograph.
yeah, after the photograph.
Yes.
And perhaps, my lord, so far my understanding, my lord, the mismatching they are saying as regards to this admission certificate. But I should be very candid, my lord. My lord, so far the other documents, well, last occasion, your lordship has considered the report of the, my lord, question documents bureau. My lord, in others documents, all the signature is matching, my lord.
Yes,
All signatures.
recording.
Yes, yes.
Actually,
Field,
order.
everything, medical examination, field, everywhere, my lord. And there is no case of any impersonation, my lord. When my offer of appointment has been cancelled by the CRPF authority,
Now
my
I
lord.
am asking him, how is this admission certificate?
My lord, this
issued?
is not my domain, my lord.
That's why I was not
Yes, my
asking
lord,
you,
yes.
but he wanted to answer. That's why I'm asking.
That
you.
cannot be.
Now you tell me, how is this admission certificate issued? And how is the candidate, when and how is the candidate required to sign on that certificate? You have to explain this process. Because that is the only signature. Now, admittedly, your document and signature on that is mismatching.
You know, that document we have received from the SSC. So whatever document we have received, the department received for this, the physical test and other things were going on. So, my lord.
Is this the answer to what is this the answer to the question I'm asking you, Mr. Nair?
In that case, my lord, if your lordship kindly give me some time.
How long? How long do you expect me to continue with this matter? In
that-
this way, none of the matters will get resolved. How long will you take?
My lord, only little bit time. The next date fixed by your lordship, I will definitely explain or whatever it may be, the consequences.
Written instructions as handed over in court today by Mr. Naik is written with the records. From the written instructions, it appears that the admission certificate available in the dossiers of the respondent authorities have been issued by the Staff Selection Commission authorities. Full stop. The signature appearing in the said admission certificate is the only signature that has mismatched with the other signatures of the petitioner. As per the report of the questioned document examination bureau, comma, CID, comma, Government of West Bengal. Full stop. Next. Mr. Naik is permitted to take necessary instructions on the issue, how the admission certificates are issued to the candidates, and when and how the candidates are required to put their signatures on the said admission certificate. Full stop. Let the matter appear for further consideration under the same heading motion bold on July 17, 2023. So I am not going to keep it pending any longer, Mr. Naik. Either you
Assure me,
give
Lord.
instructions or I am going to pass an order. Because this is now admittedly your document. I have retained the instructions with the record. Now you have to say who puts the signature and when. What is the process?
All right.
So when is he expected to be back? 17th July.
And for the respondent also.
In this matter, my lord. The similar nature of matter, my lord, she is getting MMCC. The
Lordship-
ECL has approved the MMCC from their own, but not from the date of death.
Not approved. His Lordship in 14 died. She applied for the employment. We refused. We asked to submit the MMCC form in 2006 only for dispute for 2 years. After 16, we examined and started paying from 2016. Only 2 years we have not paid because
This is the exception of my
2 years because she applied after 2 years. That is only dispute. Because when she applied after 2 years she applied, after 2 years we started
Now
paying.
you pay from May 3, 2014.
Lordship, she accepted Lordship from 2016.
Maybe,
And after 6 years, Lordship, she's
Maybe, but then her entitlement cannot be wiped off.
only for 2 years.
That only 2 year, only 2 months also you have to pay the arrears. Ashwin. The issue in this question, in the repetition,
We admitted, we never raised dispute.
whether the monthly monetary cash compensation within bracket MMCC bracket closed is payable to the petitioner from the date of such application or from the date of death of her husband. Full stop. Next. Admittedly, the petitioner's husband died in harness on May 2, 2014. Being an employee of Eastern Coalfields Limited, within bracket ECL. Full stop. MMCC has been granted to the petitioner with effect from June 18, 2016. Full stop. The petitioner has prayed for grant of areas of MMCC from May 2, 2014 till June 18, 2016.
My lord, they have started after June. This is the approval letter. So usually, my lord, don't mention the, my lord, the starting date.
From 2016, getting MMCC from 2016. Till June 2016. By filing the present writ petition in 2022. Next. Mr. Ghosh, learned counsel appears in favor of the petitioner. Full stop. Next. Mr. Kumar, learned counsel appears in favor of ECL. Full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view that MMCC has been granted to the petitioner from 2016.
She claimed from 1st May 2014.
2016. Full stop.
In terms of the letter dated 30 AM, my lord.
In terms of the letter dated June 18, 2016. Full stop. Next. This court relies on the decisions of the Honorable Division Bench in Devanti Kumari and Ambabati Mahali. এগুলো নিয়ে নেবেন citation গুলো to come to the finding that MMCC should be paid from the date subsequent to the date of death of the petitioner's husband. Full stop. Therefore, comma, the petitioner will be entitled to arrears of MMCC from June 19, 2016 till such date the MMCC was actually paid to the petitioner month by month in 2016. Full stop. Next. With the directions aforesaid, WPA 17225 of 2022 is disposed of. Bold server copy certified.
Some interest, my lord.
Not in this case.
Very.
At a server copy rake likhun.
Well,
This
only
court
thing-
has not considered the issue of interest since the respondents have started disbursing the MMCC of the petitioner within a short span of time from the application for MMCC being made before the authorities. Furthermore, since the petitioner has accepted MMCC without any demur or protest in 2016 and has filed the writ petition in 2022, such prayer has not been considered by this court.
Only my lord, my lord, the area date may kindly be mentioned, my lord. The 2nd May 2014.
I have said from the date subsequent, I have mentioned the date.
So that date may kindly.
Date I have said, na bole diyechi to. The date I have said that date. 1 second. I have said. From the date, bole diyechi, date ta me mention kore diyechi. Yes. No, 2014 er ekta date ache dekhun. Date
First-
subsequent to the date.
First May 2020 or 2nd May it would be, my lord. 2nd May 2014.
The areas of MMCC will be paid. Koto boleche? May 2. May 2.
Lord.
Yes, I have said
May 2,
that.
2014.
Yes, May 2,
A time-
2014.
Very well. A time limit may kindly be given.
Acha, such areas of MMCC shall be paid. Server copy rage within 3 months from the date of the order.
Very well.
Director Duff.
59, I beg to appear on behalf of the respondent number 2 and 3.
My lord, in 59, I am requested by Mr. Bhudev Chatterjee to make it not today only.
But on the number of
He is
occasions
busy in-
taken time, my lord, there is no scheme for pension. Lordship was kind enough to direct us to file our report. We have filed our report. Pension
Petitioner,
scheme
he
is
is
not
not the
there.
petitioner.
He is praying for.
No pension scheme, my lord.
I have understood the petitioner is praying for time. What will I do?
Only
I
for-
accommodate the respondents also, Mr.
True, my
Mukherjee.
lord, true, my lord. But at least on the 2-3 occasion, my lord,
17th রাখুন।
deeply obliged.
17th রেখে দিন। অন্যগুলো তো ডাকতে হবে।
Respondent, my lord, before my landed petition, my lord, there is a direction, my lord, to file a report. My lord, after that, just 2 days after the direction, my lord, the Cooperative Election Commission declared the election in the cooperative society. So that is the difficulty, my lord.
You have not filed the report.
No, my lord, the office bearers, they have become functions
All
office.
right, I'll extend the time to file the report. Ashun. 60.
My
You
lord,
are appearing for respondent number 7?
4, 5 and 6.
4, 5 and 6.
4, 5 and 6.
My lord, this is a election notification, my lord.
That is all right. You are for 4, 5 and 6.
Yes, my lord.
A prayer is made on behalf of the respondents number 4, 5 and 6 stroke Kalyani University Cooperative Credit Society Limited for extension of time for filing a report on affidavit. Full stop. Next. Such prayer is considered and allowed. Full stop. Let a report on affidavit be filed by July 21,
My lord,
2023.
Yeah. My lord, the first week of August. Otherwise, my lord, the election scheduled to be, my lord, completed on 14th July. After that, my lord, the delegates,
July 28, 2023.
after that, my lord, the directors had to be, my lord,
Exception
appointed.
by August 4, 2023. Full stop. Let the matter appear for further consideration under the same heading motion on August 7, 2023.
7th August, my lord.
Grateful to your lordship.